My lord,
My lord, I am extremely sorry, my lord. I am
Not take up any
no, my lord.
unnecessary.
I am mentioning this matter for taking your lordship kind leave, my lord, to file the notes of submission, my lord. My lord, on the last occasion, your lordship
No,
directed.
No notes
file-
of submissions today. Yes,
my lord, leave may be granted to more vacation bench on 22nd.
leave granted.
Leave may be granted to. My lord,
Vice. Sorry. Wait.
For judgment, item number 1.
appearing for the respondent.
এটাকে না পরে পাঠিয়ে দেবে, কারেকশন আছে। The facts which emerge from the records and the settled law of the subject persuade this court to deny the relief prayed for. Both WPA so-and-so and Acta 27132, Acta 27137 are found to be without merit for the reasons stated above. The writ petitions are hence dismissed, and the interim, there is one interim order, Mr. Day, or two interim orders?
My lord, two interim orders.
In both writ petitions,
Yes.
identical?
Yes, madam.
Are you sure about that?
Yes, madam. Yes.
The interim orders dated 9/12/2022 are accordingly vacated. Connected applications, if any, are also disposed of. There shall be no order as to costs.
Deeply obliged, my lord.
For judgment, item number 3.
The argument made on behalf of the Commission and the private respondent number 3 on the issue of participation in the proceedings is not a satisfactory defense to assumption of jurisdiction by the Commission, where the case is a private matter, simpliciter. The petitioners appearing before the Commission or writing letters to it or presenting themselves for appearance will not cure the inherent lack of jurisdiction. The question is not of the investigation being allowed to continue as a matter of course. The question is whether the investigation could have started at all. Any action or decision taken in excess or in the absence of jurisdiction would not only nullify the very initiation of proceedings, but all that follows post-initiation. The Commission cannot wrest jurisdiction where there is none. WPA 9595/2023 is accordingly allowed and disposed of by directing the National Commission for Scheduled Castes to recall and withdraw the recommendations made pursuant to the hearing held on 3/2/2023. The respondent number 1 commission shall not act in terms of the recommendations or give effect to the same. Although affidavits have not been called for, learned counsel for the parties have addressed the court on the writ petition, and the writ petition is being disposed of on that basis.
Grateful, madam.
My lord, has my lord reserved the right of the commission in so far as the question of discrimination going into the aspect of discrimination is concerned?
In this matter,
So that I was arguing, my lord, that we were actually looking into the aspect of discriminating the private respondent insofar as he is a scheduled caste vis-a-vis the treatment of a general caste
no,
candidate.
Mr. Bhattacharya, I've held that the recommendations cannot be done. Yes.
Grateful, madam.
But may I formally ask and
Of course, you have a right to. The learned DSG appearing for the commission makes a prayer for stay of the operation of this judgment. Stop. Since the court has held that the commission did not have the jurisdiction to initiate the investigation / inquiry, comma. The prayer for stay is considered and refused.
Grateful to you. Lord.
Grateful, my lord.
Item number 4,
Number 4, I beg to appear for the petitioner. My lord, I have instruction not to press
Don't
the.
know where to stand.
I am for the state, my lord.
We have instruction not to press the application.
I can't hear you. Microphone, please.
Lord, we have instruction not to press the application.
Whose handwriting is this? Yours?
No, my lord.
No. There are 3 different handwritings on this sheet of paper.
Lord, that is the client has handed over to us, my lord. We do not.
Learned counsel appearing for the petitioners hands up a handwritten letter dated 17/5/2023 to the advocate stating that the writ petition has become infructuous in view of a judgment being delivered on 3/5/2023 in WPA 8506 of 2021. Stop. Next, the letter is kept on record. Stop. Next, WPA 5213 of 2022 is dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Grateful, my
item number 5,
Lordship, this has come up at my instant for correction of the order passed by your lordship on 16th May. Lordship, in the 3rd para, last line, it has gone down as maintenance work of metro railways.
Are you doing it upon notice to the other side?
Yes,
You
Your
are there?
Respondent of her.
Yes. Is
Para
that a paragraph 3?
I have handed over a Lordship, para 3, last line,
Yes.
second page. Maintenance work of the metro railways. It will be maintenance work of various projects under KMD.
Very well. Learned counsel appearing for the petitioner mentions for correction of the order passed by this court on 16/5/2023. Stop. The last line of paragraph 3 at page 2 should read as quotation marks from the submissions made ... floated by the KMDA in relation to various project work of the KMDA. Stop, close quotation marks. Stop. Let this correction be made part of the order dated 16/5/2023 and be treated as part thereof. Part of the order dated 16/5/2023. Stop. The respondents are represented.
Grateful, Lordship.
item number 6,
My lord, matter mentioning as a correction, but it actually is withdraw. It's my client instruction.
May you please accept.
Learned counsel appearing for the petitioners hands up a letter dated 16/5/2023 from the petitioner number 1 stating that the disputes between the parties have been amicably settled. Stop, and that the writ petition should therefore be withdrawn. Stop. The letter is kept on record. WPA 9280/2023 is accordingly dismissed as withdrawn. Interim orders, if any, shall stand vacated.
Item number 7.
My lord, the matter is mentioned as correction, but actually it's withdrawn, madam.
You look at correction this,
Well, I am appealing for the respondent number 8 in this.
হিট করে কোন স্টেটমেন্ট হিট করে কোন স্টেটমেন্ট রিমুভ এটা
হ্যাঁ,
স্বপ্ন
হ্যাঁ, ওটাই স্বপ্ন এন্টারপ্রাইজ।
Learned counsel appearing for the petitioner hands up a letter of 18/5/2023 stating that the petitioner would like to withdraw the writ petition and the matter should be closed as soon as possible. Stop. The letter is kept on record. Stop. WPA 10960/2023 is accordingly dismissed as withdrawn. Interim orders of any shall stand vacated.
Grateful, your lordship.
Item number 8.
Lordship, I am appearing on behalf of the petitioner. This is for extension of interim order. Today is expiry.
I can't hear you. Microphone, please.
Today is fixed for extension of interim order. And it's expiring today.
I'm for the respondent, my lord.
Yes, what do you have to say?
My lord, this is Benami property matter. And affidavits have been exchanged, filed, my lord.
Very well. I'm fixing in the first week of June.
My lord.
Lordship.
The interim order is due to expire today. Stop. Affidavits are complete in the matter. Stop. Next, the matter will be listed for hearing on 8th June 2023. Stop. The interim order is extended till 30th June 2023.
I'm grateful.
I'm grateful.
Item number 9.
Lord, I beg to appear on behalf of the petition.
I prefer for the state, CWC.
Lord, this is the matter, Lord, where the mother was deprived to get the custody of 4 years child, Lord.
Yes.
But on last occasion, learned advocate for the Lord, the CWC, that is Child Welfare Committee, was not present. That is why my Lord directed me to ensure their appearance.
You are appearing for the CWC?
Lord, I had given the notice to them.
Yes, what is the case? You're the mother of a 4-year-old child.
4-year child.
And the child is now presently where? Lodged where?
In respondent number 7 is the father, respondent number 8 is the father-in-law, mother-in-law. They are residing at, child is residing with them. My husband was the respondent number 7, who was arrested in connection with the case, criminal case, which was started against by my client. I'm not in the FIR specifically stated that the child was custody of the child was taken away from my possession and I was driven out from my matrimonial home. Then, Lord, on the next date, I filed an application before the CWC, all the state authorities, that these are the incident, kindly make an inquiry and to take step in accordance with the section 29 of the Act. Lord, thereafter, I was called upon by the respondent number 4 at his office at Barashat. Then, Lord, I was scolded there and the proof was perpetrated upon me and to give an undertaking before the respondent number 4 so that the child can remain with the respondent number 7, who is the father-in-law, aged about 71 years, and I may have the visitation right.
Father is aged 71 years.
Father-in-law.
So the child is with the father and the in-laws of the father.
My lord. And that is my blood. The
Not in-laws, parents of the father. Your in-laws.
My lord.
Yes, Mr. Gaurav, what do you have to say?
My lord, 2 things.
essentially
Can't hear you.
essentially a custody dispute between the father and the mother.
Yes.
The CWC had the
Can you not
CWC
understand? Yes.
CWC has investigated into the matter. My lord, and it is found that the entire statements, my lord, it is essentially they want the custody. My lord, the CWC is not the competent person to decide on the custody. That they will have to approach the concerned court. My lord, with reference to the allegation statements made by against the police, my lord, I have a report from the Belghoria PS. If your lordship wants to look into it, my lord, necessary steps have been taken. FIR has been lodged against the father. He was in custody. He was now out on bail.
No, so what is the allegation against the police? Inaction?
No, nothing.
The-
Yes.
No allegation against the police blood. My allegation against the blood is CWC. Respondent number 4. When the notice was, when I was called upon by them
It is a custody battle between you and the respondent number 7. Why are you before the writ court? CWC does not have the jurisdiction to decide who will have custody of the child.
blood, kindly consider two provision, blood. Kindly consider blood, the two provision.
Yes, give me the book, please.
205. Page 205 first. Section 30, subsection.
Section?
Section 30, subsection Roman 6.
Rules too.
So is the child under the CNCP category? Child in need of care and protection?
No, not that blood, the child. is-
Then the CWC doesn't have any jurisdiction at all. Come to the provision, please. Child in need of care and protection.
Subsection 14.
My lordship with subsection 14,
14.
Roman 5. If we wants to come under that, who has a parents or guardian or such parents or guardian who is found to be unfit or incapacitated by the committee or board to care for. Well, he wants to come under that. Well, there is a recommendation.
Microphone, I can't
Well,
hear you.
there is a recommendation. I have the soft copy. My lord, where they have gone into it and have not found such case to be made out. But I have those.
Who has gone into it?
CWC has gone into those allegations made by in the complaint and has found. My lord, I have a soft copy. If your lordship kindly keeps it up, if your lordship wants, I can hand it over. Kindly then give me.
Yes, give me the soft copy, please. On the phone. Yes, give it to me.
There is a recommendation, your lordship. Thereafter, my lord.
Some messages are coming while I'm reading this. That is all right, isn't it? What is the date of the recommendation?
My lord, the date of the recommendation is
25, yes,
section
yes.
25.
So it is there. And this recommendation is by you.
The recommendation is by the, I have to just check that. I also just got the recommendations sometime back. উনি বলেন। আমার যা বলার আমি বলে দিয়েছি, এর থেকে বেশি আমি বলবো না।
So the CWC was directed to recommend it
Yes,
to make a
there is-
social inquiry. Have you
There is
done
a
that?
social inquiry done, but there is, my lord, if you look, I have got the social inquiry report also.
So you're showing me something else.
No, this
So
is the
what is the,
recommendation. I can hand, my lord, that's there only. I have to. Lord, you will kindly get back. There is a,
in that document
it-
itself?
no, not that document, the next document that is there in the message.
I don't know, Mr. Gorai, if you have come for the matter, this is not,
Just,
why have you not
just,
got
Lord, you
this
will
in?
give me 15 minutes time. I'll come back with the printouts. I'll just,
Yes, come after 15 minutes, please. You should have come ready with these documents. After 15 minutes. Yes, next.
আমি কিচ্ছু দেখাবো না।
Item number 10,
I appear for the petitioner, my lord.
Lord, I'm appealing for the respondent, all the
My lord, petitioner is, my lord, assistant headmaster of a school, my lord. He was, my lord, he is hailing from, my lord, he is hailing from, my lord, scheduled caste community, my lord. And a certificate has been issued to him, my lord. My lord, this certificate was, my lord, verified for umpteen number of times, my lord. In spite of that, my lord, in 2021, my lord, another proceeding has been, my lord, initiated against him, asking him to deposit the, my lord, certificate as well as to show cause why his certificate should not be, my lord, cancelled. On the grounds, only one grounds has been stated, that he is not, my lord, hailing from, my lord, Namashudra community. He is not, my lord, scheduled caste. That is the only grounds stated in the show cause. But, my lord, in the impugned order, several acquisitions have been made.
No,
My lord.
impugned order of passed by who?
SDO, my lord, Subdivisional Officer Jhargram at page 79, my lord.
Where is it?
My lord, annexure P14, page 70, starts from P79.
79 to 84.
Where is the material part?
Material, yes, my lord. Material part is, my lord, that
Page 79 is a coordinate benches order. What are you
yes, my
saying?
lord, annexure P14, probably, my lord, there is pagination, there is a mistake in pagination, my lord.
No, then correct it and come back after the holidays.
My lord, kindly see,
No, no, no,
my lord,
no.
that is the last page, my lord. Last page is the, my lord, the.
What is the interim order you want?
I want, my lord, that cancellation order, operation of the, my lord, cancellation order may be, my lord, stayed. Because, my lord, impact of this order is this, my lord, the West Bengal Secondary Education has, my lord, issued charge sheet. And I have to, my lord, make, my lord, my reply within 15 days from the date, my lord, that is, they have issued on 10th May, my lord.
So give the reply.
My lord, if charge sheet is not accepted, my lord, then, my lord, my service will be terminated in the meantime, my lord. Because, my lord, kindly sees.
Yes, which page?
My lord, that is the, my lord, that is last part, one page, my lord, that is page 83, my lord. Last page, that is the order. Internal page 5 of the, my lord, impugned order. Last paragraph, my lord.
Yes,
Therefore, I, the Subdivisional Officer Jhargram.
I can't hear you. Speak clearly into the microphone.
Therefore, I, the Subdivisional Officer Jhargram Sodor and Caste Certificate Issuing Authority came into conclusion that alleged certificate holder Sri Niranjan Manna, son of late Indrajit Manna, village Osurhata, post Nekrasol Police Station, Noyagram District, Jhargram, presently residing at Raghunath, Jhargram, does not belong to Namasudra community, which is mentioned in his scheduled caste certificate. Rather, he belongs to Napit community, which is recognized as OBC, and satisfied that the alleged person, Sri Niranjan Manna, son of late such and such, of such and such, Jhargram received his scheduled caste certificate as subcaste Namasudra by knowing misrepresenting facts. Those are not stated in the show cause petition, my lord. Knowing furnishing false information, that is not stated. Knowing suppressing actual fact, that is not figured in the show cause notice, my lord.
No, what is the basis? There are some sections in the act.
Yes,
On
yes.
what basis are you seeking a stay?
Yes, my lord. That is the, my lord, SC/ST identification rules.
Yes.
That is the relevant rules, my lord.
Yes.
There it is stated that in the show cause notice, they are, my lord, the competent authority is required to, my lord, state all the grounds. Then I have to, my lord, give reply. So I did not have opportunity to explain those things.
Where is the show cause notice?
Yes, my lord, at page, my lord, 38. Annexure P8, my lord.
Yes.
My lord, I'm reading, my lord. Whereas you obtained a schedule caste certificate from this office, by certificate such a member of Namashudra community. And whereas it is ascertained through inquiry by competent authority that you actually belong to Napit community, which is recognized as OBC category B. And whereas I, the certificate issuing authority, decided to start proceedings for cancellation of your schedule caste certificate in terms of Rule 3.1 of the West Bengal Scheduled Caste and Scheduled Tribes Identification Rules, 1995. Therefore, in terms of Rule 3, Sub-Rule 3 of the West Bengal Scheduled Caste and Scheduled Tribes Identification Rules.
So you have replied to this?
Yes,
the show
yes,
cause?
I have replied.
Where is it?
Yes, my lord. That is my lord.
It's 39, my lord.
Page 39. Yes. No, page 40 starts from page 40, my lord.
39 থেকে তো শুরু করো।
That is Annexure P9, my lord. Address to Sub-Divisional Officer.
So why are you saying that you were not given an opportunity to respond to this?
Because, my lord, they have not stated that the misrepresentation has been committed, and I have, my lord, procured false
No,
certificate.
no, have you said all that in your
Yes, yes,
reply?
my lord,
Where?
I have stated in the explanation.
No, no, you started with saying that you were not given an opportunity. So this is the opportunity,
No,
page
my lord.
40.
All I am saying, my lord, in so-called notice only stated that I am not belong to, my lord, Namashudra community, and not more than that. But, my lord, kindly
Where
see-
does, show me the rules? Where does it say that the show cause notice has to give all these
Yes,
things?
ma'am.
Say all these things. Yes. Show me the rules, please.
Yes, ma'am.
কথা বললে কিন্তু শুনতে পারবে না। জিজ্ঞেস করো কোন বইটা লাগে।
My lord, this is the rule. My lord, kindly see Rule 3, Sub-Rule 3. And also, my lord, it is supported by the judgment is
বইটা আছে তোমার কাছে দাও।
procedure for cancellation, impounding or revocation.
Rule?
3.
Yes.
Sub-Rule 3, my lord.
Yes.
The certificate issuing authority shall then issue a notice to the holder of the certificate to show cause within 15 days or within a period of shorter duration, as it may think fit, as to why the certificate issued in his favor shall not be cancelled, impounded or revoked on the ground stated in the notice, my lord. So only one ground is stated, that I does not belong to, my lord. I do not belong to, my lord, Namashudra community. That is the only ground.
Yes.
But the acquisitions are different. Several acquisition. My lord, kindly sees the last but one page of the, my lord, order. That was not, my lord, given to me. I was not aware that I have to, my lord, reply to those queries, my lord. That is the internal page 5.
So you're mentioning ground 6 at
Six.
page 84,
84, my lord.
the 6 grounds.
6 grounds, yes, my lord. Those are not stated in the, my lord, so-cause notice. So I did not have occasion to, my lord, reply to those queries, my lord, or to explain those, my lord.
So did you get an order from Justice Bhattacharya or not?
It is for the first time after.
I can see Justice Bhattacharya's order on record.
Yes, yes, my lord. That is Krishnapada Sardar, my lord. In this order, it has been, my lord, stated that all the grounds are to be, my lord.
Not Krishnapada Sardar, your order on 1/4/2022.
Yes, my lord. That special, my lord, report has been asked for from the authority, whether earlier any proceedings were initiated or not, my lord. I have stated that there were more than 2 proceedings where, my lord, initiated by this competent authority.
Yes, very well. I've understood. Yes.
Can you
What do you have to say?
By means of fraud, my lord, by obtaining fraud, he identifying, by he himself identifying as a scheduled caste community, though.
No, he maybe.
Maybe, my lord. Your
Maybe.
lordship, kindly
Have
kindly
you followed the rules or not?
Yes, my lord, your lordship, your
You
kindly-
may be actually absolutely correct on facts
My-
that there is misrepresentation, fraud, but did you follow the rules or
Yes, we
not?
have followed, not. This was heard by Justice Mantha, my lord. Report was submitted, then Justice Mantha called for a report from the ADM. The report which was submitted before, my lord, Justice Mantha, that is the report, not perhaps it has been kept on the record. I have got my copy and then the ADM report. Your lordship, kindly the 2 reports. On first April, not 2022, the report of SD was submitted. After seeing the report, Justice Mantha asked the ADM to submit a report.
My lord,
Then we
on,
have both the report, your lordship kindly see.
on 1st April, my lord, report was asked for, not submitted, my lord.
Lord, I
Kindly
have
see-
got my copy
না না
also.
ওটা সাবমিট করতে হলে তারপর কোনো on
Have you not got a copy of the report?
no my lord
No.
no my lord because on 1st
Lord-
April they were asked to my lord supply my lord to furnish the report thereafter only for the first time today my lord, this is being taken up for consideration so
No.
I did not have occasion
No,
to
it
my
is
lord
not. Not on 1st April, it was heard by Justice Mantha. Your
My
lord, Justice Mantha heard this matter.
It is not a
Report was seen
question
by
of whether somebody is hearing, a learned coordinated bench is hearing the matter. Have you served the report to the petitioner or not? Can't even understand what is
Lord,
being
I
discussed.
understand, Lord. Lord, your lordship.
It
kindly
is not
see-
there in the files of the records of the
But we
court
have
also.
submitted, we have submitted. My learned junior has submitted before my lord. In court number 13, Lord. And the ADM report also is with me, your
Then
lordship.
get it
kindly
from
see-
court number 13. It's not here. From 13 to 5, the report must travel. Prima facie satisfied that interim order is
Lord, your
going to be
lordship,
granted.
kindly, your lordship, kindly
Prima
come to
facie.
the order.
Yes,
impugned,
come
your
to the
lordship.
rules, please.
Lord, your lordship, kindly come to the order impugned, Lord. Your lordship, kindly come to the.
No, no.
Lord,
Come
your
to the
lordship,
rules,
whether the
rules
fault has
first.
been played or not, your lordship, kindly see whether
Yes.
the detailed report I am to cite, Lord. Your lordship,
Yes.
kindly see the detailed report. It starts from page, how it a fraud has been created. He was page 36, your lordship, kindly come to
Page
first,
36
page
of what?
36. Page 36 of read petition. Your
Yes.
lordship, kindly see.
Yes,
Page 36, your lordship, kindly see.
yes.
Letter dated 26 March 2018 to C. Niranjan Manna. The petitioner hearing. Verification of civil caste certificate of C. Niranjan Manna. He is
Yes.
hereby informed that C. Sumiran Mandi, Governor, Convener, Bharat such and such Mahal, Jharkhand lodged a complaint and dated such and such that he obtained a civil caste certificate from the
Please,
office.
the facts are not relevant. Just show me that you have followed rule 3.3. That's all.
That I'll show it in the order.
Show that you have followed rule 3.3 in your show cause notice and then the order.
Show cause notice. I'll show you. I'll show you. Put there.
There is a procedure laid down.
I'll show you. Just one. Your lordship, kindly come to rule 3.
Yes.
Procedure for cancellation, impounding or revocation of certificate. Man, let us come to first 3.2. Where any proceedings have been started under sub-rule 1, the certificate issuing authority shall, by a written notice, ask the person holding a certificate to deposit the same in original in its office when the certificate has been so deposited, a receipt in favor. So this original certificate was not produced before the, that is as per rule 2. Let me see. Not
Please.
rule 3. Then
Yes.
rule 3. The certificate issuing authority shall then issue a notice to the holder of the certificate to show cause within 15 days. Show cause notice was issued and he has given the reply within period shorter than such and such fit as a certificate issued in favor of shall not be cancelled with. After completion of all these formalities, the order impugned, which starts from page 79, it has been passed by SDO. Then the matter, you logically come to the order now. 79.
I have seen the order. The show cause notice mentions only one ground, that he did not belong to that community,
Yes,
Namashitra
it does not
community.
belong.
The order gives 6 more grounds. Look at the order, please. Page 84. Apart from that ground, it mentions 6 more grounds. So did you give that opportunity to the petitioner to reply to the 6 more grounds or not at the relevant point of time?
Order at page 3. Let me read it out. Then your lordship pass this order.
Yes.
Let me read it out.
Till then, stay. Yes.
Then your lordship kindly see the order of the ADM, which has been passed in terms of the order of.
Yes. Just
Your
show me
lordship
that
kindly see-
rule 3.3 has been complied with, and
Lordship
that is
kindly
fine.
see the order
Yes.
of ADM.
You're not following the court.
Lord, I am
courts.
following. Your lordship kindly see the order, which has been passed, which has been issued by the ADM in terms of the order of Justice Mantha. After filing my report, which was submitted by SDO.
Very well. Get the report. Till then, don't take any action. The report is not before the court and I'm going to record it. Although learned counsel appearing for the state respondent submits that the state filed a report on 1/4/2020, 3 or 2.
SDO में the report होता है. This is the report. That is the 20th April 2022 by ADM 21.
You just said 1st April.
No, no, not the ADM report is 21st April 2022.
Which is the report which cannot be found in the records of the court.
That on 1st April we have filed.
So I'm
First April.
asking you, 2022 or 2023?
23, Lord, 23. 1st April 2022. Sorry, but
Ki bola?
the record was not actually, it has not been endorsed in my brief. 1st April 2022, it was heard before Justice Mantha. And the report of SDO was submitted.
What is the date of the report? Is it?
First date of report I have said you, Lord.
It is very difficult to converse
Lord, I
with you
have
because you're not
already
even
said,
understanding the court.
21st March 2022.
Every time you're coming up with a different answer.
Lord, 21st
Yes,
March
the learned counsel
2022.
appearing for the state respondents is not sure
Lord, I am telling you,
of
Lord.
the facts of the
Your
case
lordship
with
is not
regard
hearing
to
me.
the orders passed earlier,
Very
to the
good.
earlier orders passed, as well as the report. Stop.
Lord, report I have
Council
submitted.
gives different dates at different points of time. Stop.
No, your lordship is not
Next.
hearing me.
The report which council says was filed pursuant to an order of a coordinate bench is not before the court. Stop. Learned counsel appearing for the petitioner submits that the report was also not served
I
on the
have
petitioner.
served, but if it is not in record, it is not my fault.
Next, the petitioner has
Not
come
in
to the
record,
court.
is it my fault? Lord, your lordship kindly appreciate my submission. I have submitted the report. If the report is not in record, is it my fault? Your lordship kindly appreciate.
At a cost,
Respectfully I
cost last
submit.
দেবে তো? Yes, last at a cost দেবে, চাপাবে. Yes, কি বললাম last এ? Come to the court challenging an order dated 11/1/2022 passed by the subdivisional officer, Jhargram Shodor, SADAR, cancelling
Cancelling my custody.
the scheduled caste certificate
By means of fraud,
Of
he has
the
obtained a
petitioner.
service.
dated 14, scheduled caste certificates dated 14/11/1994 issued to the petitioner. Stop. The reasons for cancellation is indicated in the penultimate paragraph of the impugned order. Stop. The reasons are that reasons থেকে second paragraph. The reasons are that the petitioner does not belong to the Namashudra community, NAMASUDRA, capital N, Namashudra community, page 84, but to the Napit community, NAPIT, Napit community, which is recognized as an OBC. Stop. Apart from this ground, comma, the paragraph gives 6 other grounds for cancellation of the caste certificate. Stop. These are number 1, knowingly misrepresenting facts. 2, knowingly furnishing false information. 3, knowingly suppressing actual facts. 4, knowingly suppressing material information. 5, knowingly submitting forged land deed of 1941. And 6, knowingly submitting false affidavit executed by the petitioner's father. Stop. The language used is of the SDO and not of the court. Stop. Next. The other documents on record show that the petitioner was issued a show cause notice by the concerned SDO on 30/12/2021, stating that the competent authority has ascertained through inquiry that the petitioner belongs to the Napit community, NAPIT, which is recognized as OBC within brackets B, close brackets. The only ground mentioned in the show cause notice is that the SDO in exercise of Rule 3 within brackets 3 of the 1995 rules, directs the petitioner to show cause in writing as to why the petitioner's scheduled caste certificate shall not be cancelled. Stop. The reply was to be given within 10 days from the date of receipt of the notice. Stop. The petitioner replied to the notice on
On my third line.
3/1/2022.
Before parting your lordship's order, your lordship kindly also look to page 37 and 36 both.
The other documents show that the petitioner was also asked to appear. Another communication dated 12/2/2019, which is 2 years before the issue of show cause, indicates that the petitioner was requested to appear before the additional district magistrate on 14/2/2019 with the petitioner's original caste certificate. Stop. Next. The relevant rule, as mentioned in the show cause, is Rule 3 within brackets 3 of the West Bengal Scheduled Castes and Scheduled Tribes within brackets identification, close bracket rules, 1995. Stop. The rules were notified on 14/10/1996. Stop. Rule 3 within brackets 1. Rule 3 deals with procedure for cancellation, impounding or revocation of certificate. Stop. Rule 3 within brackets 1 provides that a certificate issuing authority on a complaint made by any person or suo motu, M-O-T-U, suo motu, shall hold a preliminary inquiry whenever it appears to that authority that a scheduled caste/scheduled tribe certificate has been issued, that the scheduled caste/scheduled tribe certificate that the person to whom the certificate has been issued does not belong to the scheduled caste/scheduled tribe. Stop. The certificate issuing authority shall satisfy himself/herself prima facie as to the truth of the complaint, record the reasons of the satisfaction as to the truth of the complaint, and start proceedings for cancellation if necessary. Stop. Rule 3 within brackets 2 provides that the certificate issuing authority by written notice shall ask the person holding the certificate to deposit the same in original in its office where any proceedings have been started under 3 within brackets 1. Stop. Rule 3 within brackets 3, which is next paragraph, which is relevant for the present writ petition, empowers the certificate issuing authority, authorizes the certificate issuing authority to issue a notice to the holder of the certificate to show cause within 15 days or within a shorter duration as to why the certificate issued in his favor shall not be cancelled on the grounds stated in the notice. Stop. Next, in the present case, comma, the only ground stated in the show cause notice dated 30/12/2021 is that the petitioner obtained a scheduled caste certificate for as a member of Namashudra community, whereas the petitioner actually belongs to the Napith community. Stop. The petitioner replied to this allegation. Stop. The impugned order, however, dated 11/1/2022 mentions 6 other grounds, including that the petitioner submitted a forged land deed of 1941 and knowingly submitted a false affidavit executed by the petitioner's father. Stop. It is evident, therefore, that the impugned order was passed on additional grounds other than the ground mentioned in the show cause notice, which naturally means that the petitioner was not given an opportunity to respond to the grounds, to the additional grounds. Stop. Next, apart from this being in patent breach of the principles of natural justice, comma, it is also ex facie contrary to the mandate of Rule 3 within brackets 3 of the 1995 rules. Stop. Next, no report, comma, if it is assumed that such report has been filed by the state respondents, comma, can cure the defect of the can cure the defect of compliance of Rule 3 within brackets 3 of the 1995 rules. Stop. Next, until the report is found in the records of the court or counsel appearing for the state supplies a copy of the same, there shall be a stay
Lord, I'm supplying it.
of the
Lord, I'm supplying it. I told you my
of
my
the
lord.
impugned order dated
11th January.
11/1/2023. Stop. The report, a copy of the report shall also made available to the petitioner. Stop. Next, list this matter on 13 June 2023.
Lord, I have
The
submitted. on
petitioner
ATM
shall
report.
have the opportunity of responding to the report by the returnable date.
Lord, I have submitted
My lord,
on
stay in the
report of
meantime, my
ATM, Lord, your lordship.
My lord, stay of the order in the meantime.
Call on the next matter, please.
Lord, the ADM report, may I take it back or your lordship will keep it in on
You can
record?
take back everything. Completely unprepared for the matter. Call on the next matter, please.
What I have submitted, Lord, before my lord.
Cost
Justice.
on council. Cost on council, ওটা আমি পরে দিয়ে দেবো. Next, call on the next matter. Cost on council for disturbing the court. Amount টা দিয়ে দেবো পরে. Call on the next matter.
Lord, excuse me, I am
Yes,
not, Lord, I am
passed
not
over
disturbing
matter.
my lord.
Passed
Just
over
I am
matter.
making submission on behalf of my client. Your
Passed
lordship
over
kindly
matter.
Pass over matter item number 9.
Your
Passed over
lordship
matter.
kindly appreciate, Lord.
Pass over matter item number 9.
Lord, I beg to appear on petition.
I'm for the respondent number 7.
Yes,
Lord, that matter-
CWC has not come. My lord, may I submit my submission, my lord.
It's a private dispute for
Yes, my
custody.
lord, it's a private dispute of custody.
Lord, may I
And
submit?
secondly, my lord, I want to refer one section, my lord, section 2710, because no order has been passed till date by the CWC. He is aggrieved by the procedure, by the committee functioning. The my lord, let's come to section 27, subsection 10. May I read? Section
27.
27, subsection 10. As because no order has been passed, and if passed, it would be an appealable order, but he is aggrieved by the functioning of the court, functioning of the CWC. For that purpose, section 27, subsection 10.
Yes, so you're saying the district magistrate is the authority?
Is the authority, district magistrate shall be the grievance redressal authority to entertain any grievance arising out of functioning of the committee. As because he is challenging the functioning of the committee, my lord, because no order has been passed till date. This is my second way of submission. Third way of submission is, my lord, his only grievance is that the husband, the father of the child is now...
His grievance is not against the father-in-law.
Not father-in-law, my lord, father.
71 years. That's
Yes.
what you're saying.
My lord,
Yes, that is.
application before the CWC, my lord, at page... What ground he has
Sir,
stated?
Page 25, paragraph, third paragraph. Page 25, my lord.
Not third paragraph, my lord, at page 25.
1
third
minute,
paragraph.
please.
At present, the situation of my child is staying alone at my matrimonial home, unattended, neglected, because my father-in-law is 73 years
I'm
old
telling you,
person.
it's against the father-in-law. You're going on saying father.
My
Yes.
and child, and because the father is in custody, that's why he made this application. But now he is out on bail and he is taking care of the child. And there is no allegation that the father is ill-treating the child, my lord.
Very well. Yes, Mr.
No,
Gorai, hurry up, please.
But there is
Minute.
allegation against the father also, my lord.
No, no, you go to the correct forum, not the writ court. It's not a private,
Yes, ma'am.
it's a private custody battle. What is this, Mr. Gorai?
This is based on the
What is a social investigation report?
social investigation report is the pursuant to the document has shown the recommendation, a social investigation was carried out by the committee.
What is a social investigation
Well,
report?
they
I'm
find
asking
out
you.
whether the child is really in distress or not, whether they
Yes.
require the help or not, whether the
Very well. What is the report? What does it say?
well, based on that report, this has been passed. That there is now no such no such things could be found out, and therefore it essentially is a custody battle. If your lordship kindly looks.
Yes.
Blood, one more section, blood, only the one more section. Blood, section 14, kindly consider, blood, the section 2, subsection 14, and Roman, blood, the 3A. Kindly consider this section. Section 2, subsection 14.
Yes, child in need of care and protection. The
Next,
report
blood.
is that it is not, he is not a child. Child, yes, son or daughter?
Son, blood.
Son, very well. The petitioner
Social investigation report.
has come before the court seeking an order on the state respondents for custody of the petitioner's minor child. Stop. The petitioner is the mother of a minor child who is presently 4 years of age. A minor son who is presently 4 years of age. Stop. The minor son, the petitioner's son is in the custody of the petitioner's estranged husband and his family. Stop. The husband is respondent number 7 and his parents are respondent numbers 8 and 9. Stop. The petitioner complains that the child is required to be in the custody of the petitioner, who is a natural guardian of the child. Stop. Next. Learned counsel appearing for the petitioner relies on section 30 within bracket 6, choto 6, Roman 6 of the Juvenile Justice within brackets Care and Protection of Children, close brackets Act, 2015. Stop. Section 30 deals with the functions and responsibilities of the Child Welfare Committee, defined under section 2 within brackets, defined under section 2 within brackets
Not 14.
17 of the Act, and also in 27, section 27, 217 and section 27 of the Act. Stop. Council submits that the function of the committee is to ensure care, protection, and appropriate rehabilitation of the petitioner's child, which the committee has failed to do in the present case. Stop. Capital C. Stop. Next. Learned counsel appearing for the CWC / Child Welfare Committee / respondent number 4 submits, places a social investigation report, capitals, dated 8/5/2023, carried out by the CWC, carried out by the members of the CWC,
No, this is not.
as recommended. Sorry,
This is not the social investigation. Social investigation report.
I
is-
can't hear what Ms.
This is not the social investigation.
Then what have you handed up to the court?
This is based on the the findings of the committee. That is it. The
As
social
has handed up the findings of the committee pursuant to a social investigation report. Stop. The findings are dated 8/5/2023. Stop. The committee has found that the child is not a child in need of care and protection, and that the issue is one of custodial battle, a custodial dispute on the guardianship of the child. Stop. Next. Section 30 within brackets choto 6 deals with the responsibilities and functions of the CWC for the safety and well-being of children who are in need of care and protection. Stop. A child in need of care and protection has been defined in section 2 within brackets 14 of the Act, and includes the situations in subsections choto I hyphen XII within brackets. Stop. The CWC report categorically states that the petitioner's child is does not qualify under section 2 within brackets 14 of the Act, and hence section 30 within bracket 6 will not apply, will not assist the petitioner in the present case. Stop. Even otherwise, next, even otherwise, comma. Section 27 within brackets 10 of the Act relating to Child Welfare Committee empowers designates the district magistrate to be the grievance redressal authority to entertain any grievance arising out of the functioning of the committee and the affected child, as the case may be. Stop. In the present case, the petitioner has not made any complaint against the committee. Stop. This is also, even if such complaint had been made, the duties of the committee as provided under section 30 will not apply, since the child has been since the CWC has reported that the child is not a child in care of need and protection as defined under the Act. Stop. Next. This is a custody battle between the petitioner and the respondent number 7, Simpliciter, Simpliciter. Stop. The writ court is not the appropriate forum for adjudicating that dispute. Stop. The petitioner has to approach the appropriate forum for seeking custody of her child. Stop. WPA 11509 of 2023 is accordingly dismissed for the reasons as stated above. Stop.
One more thing, Lord. If such application is submitted by my client with appropriate court of law, Lord, let there be a direction to expedite the matter. Otherwise, Lord,
What are you saying? There is nothing submitted and I will give directions for expedition of the matter. Yes. Very well. Call on the next matter, please.
Item number 11.
May I please, your lordship, my lord, I am for the petitioner, your lordship. There has been an inadvertent error in the service.
Can't understand.
There has been an inadvertent error in the service of the writ petition, because instead of the local office, it has been served on the head office. May I come back after vacation upon fresh?
So you don't want the head office to appear in the matter?
No, it was wrongly served on the Mumbai office. Mr. Kormukar is appearing for the contest.
I'm for the respondent number 3, my lord.
Respondent number 3.
Another financial institution.
In any case, I wouldn't have entertained the matter. It's a SRPC action.
Your lordship, I'm not a borrower in the matter, your lordship.
You don't have to be under section 17(1) of the SRPC Act. Your forum is the DRT, not here.
And my lord, this is also premature application, because the application is pending before the DRT. That is very hard.
My issue has already been decided,
Another
but it has
application
been
is filed before the, my lord, 220 under 227 before the Honorable Court as Justice Patnaik.
Very well. The prayers in the writ petition are against the respondent 3.
1 as well.
1 and 3.
Yes.
Respondent numbers 1 and 3. Which is a State Bank of India and an asset reconstruction company. Stop. Learned counsel appearing for the parties submit that the matter relates to a SRPC action and that the petitioner is not.
No, not the surface action, your lordship.
Very well. Stop. What is it that you want?
Your lordship, I am a mortgage secured creditor of my land.
Very well. Learned counsel appearing for the petitioner submits that the service of the writ petition has been made to the wrong respondent. Stop. List this matter. on 19 June 2023. Stop, service to be corrected in the meantime. Next.
Item number 12.
Will I beg to appear for the state respondent?
Lordship, I have the petitioner, Lordship. Lordship, the petitioner
Can't hear you, Mike.
petitioner technical bit has been rejected, Lordship. That is at page 98F, Lordship. It's a typed copy.
Page
98F.
98A.
F.
F. Rejected when?
After rejection, Lordship, I immediately filed it, Lordship.
When was it rejected,
6th
Mr. Paul?
April 2023.
2023, Lordship.
6th?
April.
6th April 2023.
And what is the bid for?
Lordship, bid for supply of cooked diet, supply of security and scavenging to the ESI hospital, Lordship.
You're saying cooked that?
No, no, it's not cooked diet.
Yes.
Lordship, it become habit. Lordship, 98F, Lordship, 8 ground are there.
Yes.
First, Lordship, notice inviting tender section 1 to 15. No authentication has been found from bidder. Lordship, there is as such no clause that I have to submit this with authentication. My signature is there. Rubber seal is there, online seal is there, everything is there, Lordship. And number 2, Lordship, MSME attached Xerox copy, but not annual turnover pages not uploaded. Kindly, Lordship, page, Lordship knows that MSME certificate is required for getting price relaxation, security deposit and other deposits.
Yes.
And that in the tender bid, there is no whisper that MSME certificate should carry such certain amount of credential. Nowhere stated. MSME certificate for price relaxation. If you have MSME certificate, you can get the price relaxation. If you don't have, you will not get that relaxation, Lordship. And Lordship, number 3, Lordship, ESI and EPF scan copy uploaded. Lordship, kindly turn page 32, Lordship.
Yes.
Lordship, 10.5, technical proposal, non-statutory comfort. 10.5.2, Lordship, kindly see. Next, click the tab, click to encrypt and upload, and then click to technical folder to upload the technical document using multiple scan, black and white scan. Scan resolution should be within 250. So I have to submit scan copy. And in box, Lordship, ESI and EPF has been mentioned. Roman 4 ESI code number, Roman 5 EPF registration. So I have to submit scan copy, Lordship.
Yes.
And Lordship, next, Lordship, all are frames, Lordship. Contract Labor Regulation Abolition Act registration valid 24/1/2023. Lordship, kindly turn, Lordship, page 16, the date of floating tender. 19/12 to page 16, Lordship. (19/12/2022). And Lordship, 7, online bin submission closing date 16/1/2023.
Yes.
So registration validity 24/1/2023. At the time of submission, it was valid. And before.
Where are you getting that date from?
Lordship, 7, Lordship. Page 16 in the box 7.
7 says 16/1/2023.
23, Lordship. Last date of submission.
16/1.
16/1/2023. And it was valid till 24/1/2023 as per their record, page 98F. They have stated that it was valid up to 4th January 2023.
Yes.
So at the time of submission, it was valid.
Yes.
And Lordship, I have the documents, Lordship, that before expiry, I cannot renew it. And I have renewed it, Lordship, which I have submitted before your Lordship, Page 93, Lordship.
Yes.
Lordship, renewal, date of renewal 21st January 2023, date of expiry 24th June, January 2020. It has been renewed. On 21st January 2023, it has renewed, and expiry date now 24th January 2025. Page 93.
No, it was renewed after 24th January.
Lordship, because expiry date 24th January. Before
Yes.
that, I cannot renew it.
Yes.
On the date of expiry, I have renewed it, Lordship. And
Yes.
Lordship, next ground, what they have stated, Lordship. Performance statement and credential duly notarized Xerox copy uploaded and value which are shown in the statement has not supporting certificates. Lordship, kindly turn page 32, the clause. First, I shall show the clause.
Yes.
Lordship, performance certificate, Lordship, there is a B, C, Roman, capital C, Lordship, in the box.
Page 33.
32.
Yes.
Performance statement as per section Roman 9 along with documentary evidence. And Lordship, that is 44, Lordship. Section 9, performance for statement, page 44. This is the pro forma in which,
Speak clearly, Mr. Paul.
this is the pro forma, Lordship, in which I have
Page.
44.
Yes.
32 speaks about a statement has to given in as term section 9, Lordship, Roman 9. And that has been in 44, page 44.
Yes.
Lordship, now turn, Lordship, what I have submitted. Lordship, page 51
What is it
onwards,
that you want, Mr. Paul? This is not the kind of matter I want to hear now.
Lordship,
What is it
technical
that you
bit
want?
has rejected, Lordship, without
It
any.
was rejected on 6th April.
Lordship, I have filed it immediately, Lordship.
Yes, yes. So what is the relief you want?
Lordship, my relief is that let my technical bid be allowed and my bid should be considered at the time of.
No,
financial
Mr.
bid.
Paul, I will not give you that relief.
So, Lordship, all the grounds.
If you want, you can move the vacation bench. I will not give you that relief. I'm telling you. I will not give it to you. So you can move the vacation bench. I'm giving you that option to try some other court, but I will not give it to you. I'm telling you.
Lordship, if I Lordship try, I'm trying to satisfy you, Lordship.
No, Mr. Paul, I'm not satisfied because I will not entertain these matters on the last day. Tender. I made it very clear.
Lordship,
So I'm
then
giving
not
you leave to move the
That
vacation
order
bench.
passed, your Lordship, help me, and they have cancelled the tender, Lordship, last order also. And they have.
Mr. Paul, please, these matters will not, I will not entertain these matters. You can go to the vacation bench.
Lordship, Monday vacation bench, Lordship, it can be, Lordship, after that.
Yes, because you've already waited. This is 6th, 4th,
Lordship, because
6th April. Today we are almost.
I have mentioned this matter, Lordship, and Lordship directed to appear as a fixed matter, and it was appeared 32, sometimes 35, Lordship, it was not taken up, Lordship. I did not mention that further, Lordship, to disturb your Lordship. Now today is taken up, Lordship. That's why, as per my information.
Very well. Just what do you have to say, Mr. Galib?
Lordship, shortfall notice.
Yes.
These are the shortfalls which my learned friend has, my lord. Very much legal because there is shortfall, non-compliance with the various clauses of the NIT, that is notice inviting tender. As per clause 19.6, all the 12 bidders were given a prior notice. Please, you comply with all this. 3 notices were served upon him. He did not comply. Thereafter, my lord, financial bid was.
No, 3 notices served after the NIT.
No, after opening. No,
Yes.
before opening, when that evaluation was going on.
Yes.
Because my learned friend has challenged the evaluation report of the tender committee.
Yes.
When the evaluation was going on, there were altogether 12 bidders. We found these shortfalls of all 12 bidders. We served notice to them. Please comply with. So far as the petition is concerned, as many as 3 notices were served upon him. 1 over his email, physically by post. He did not turn up. Thereafter, my lord, out of these 12 bidders, only, my lord, 8% turned up with their reply and clarification. Out of 8, we found the clarification of 4 persons to be satisfactory. And thereafter, my lord, we opened the, my lord, financial bid.
No,
My lord.
technical bit.
After technical bid,
Yes.
Shortfall, they did not comply with despite notice. Out of 12 bidders, 8 turned up with clarification. He did not. The petitioner did not. So out of 8 bidders who turned up with clarifications, we found four complied with it.
Yes.
So the moment we found this, we opened a financial bid. In the financial bid, we found that out of 4, 2% gave zero offer. 2% gave offer. As per the latest Millard guideline, if there is draw, means 2 have not given any offer, 2 have given the offer.
No, so what is the status now?
As on date, Millard, it is lying with the Shastro Bhavan, Health Department, because out of the 4 successful bidders, after opening of the financial bid, 2 have given zero offer and 2 have given the financial offer. So rule is that if 2 persons are giving offer, it has to be sent before the Health Department. So now presently it is pending with the Health Department.
Very well.
Lordship, I'm sorry.
Yes.
Lordship, this is also an arbitrary action, Lordship. Lordship, kindly go on page 35, Lordship. They can't do this. This is my specific allegation that they are trying to cover up the loopholes of the respondents, other respondents.
Yes.
Page 35, last clause, 18.6, Lordship.
Yes.
If any documents required to be submitted for tender by the bidder in his technical proposal is not submitted or is found to be deficient in any manner at any stage after opening of bid, the bid may be summarily rejected.
Yes.
Lordship, I am sure that my bid is proper and perfect.
Mr.
They are trying to
Paul,
cover up the others'
Lordship.
lacuna.
Mr. Paul, if all 12 bidders were called, why did you not go?
Lordship,
I'm
only one exception, Lordship.
page 100.
My learned friend is relying upon 18.6. That is after opening of the bid.
Yes.
Lordship, may I take
Yes.
your lordship
Lordship, this
to
is the after
No,
opening
no,
of-
19.6, my lord. It says
I've made
using evaluation.
in June or before some other court, hopefully. Yes.
Lordship, then Lordship, vacation will, because they are.
Vacation
as per
bench, you want to
Lordship,
move? Very well.
Because
Yes.
they are saying that they are.
You said that right in the front, right at the moment you said cook diet, I should have asked you to go before the
Lordship, it will
vacation.
continue after vacation.
Yes,
It will continue after vacation or not?
Mr. Paul, you are so much. The fact that this is for security services, that has also escaped you. Yes, and if you call yourself Z plus security, I would have also rejected your bid. Your name is Z plus security. Yes,
Plus 6th April upload of the tender and 19th April is the affirmation date.
very well. Yes, learned counsel, since learned counsel appearing for the petitioner seeks urgent interim relief, comma, counsel is given leave to move the vacation bench.
Much. Lordship, affidavit service may be filed here.
Lordship.
The affidavit of service is kept on record. Take Mr. Ghalib's convenient date and move the vacation bench.
Lordship.
Item number 13.
No, my lord, I must be very short and precise because time is the factor today. No, my lord, the tender which was floated, e-tender by the PWD, Public Works Department Roads.
Mr. Banerjee, have you come against a rejection of tender?
No, my lord, so far my,
I will give you leave to move the vacation bench.
no. My tender is rejected very well. I don't mind. But the person whose tender has been accepted, they are not even eligible.
Yes, so go for the vacation bench.
Okay,
Your
yeah,
case is even better.
আরে vacation আমি থাকবোই না ভাই আমার তো miss হয়ে যাবে।
Mr. Banerjee, go for the vacation bench. Even better. You're not only complaining about your rejection, you're complaining about the induction of the private respondent. So that's a very good case which must be heard by the
No,
petitioner.
very good reason. That is why I'm knocking your lordship's door. I'm begging 5 minutes time.
No. Mr. Banerjee,
Kindly-
no, I will not entertain this. I'm giving you leave.
Kindly pay me 5 minutes time. 5 minutes time.
Mr. Banerjee, no, I'm giving you leave to move there because I will not give you relief. I'm telling you.
Work orders has been issued, my lord. Now,
Mr.
No, my lord, don't trust, with all respect. In other day, I moved applications and he says, my lord, everything is over. I say, very well. My lord says, Mr. Banerjee, everything is what I'm going to do. I'm very well.
Mr.
I'm 1
Banerjee,
minute.
Mr. Banerjee, the moment I saw you sitting over there, I thought of pointing to several council and saying vacation bench, vacation bench, vacation. I did not do that.
Kindly, my lord, this is against the notification. So my lord, for the time being, nobody will be affected what relief I'm asking for. I can assure you.
Nobody?
Will be at the present moment. Nobody will be affected for their reasons. But knowing fully well, the persons who are not eligible, they have been declared eligible for obvious reasons. Their own circular government policy is this: if the tender is less than participant less than 3, it will be cancelled. Only to cover up this, the 2% has been brought in. Just one page. Kindly come to page 41.
No, Mr. Banerjee, why are you showing me? I will not give you the relief. I'm giving you that chance to move the vacation bench. What is the date of the rejection? What is the date?
Date of
13th April.
13th April.
Work order issued, work has commenced.
Very well. Mr. Banerjee, go for the vacation bench, please. Yes, the petitioner is has challenged.
My lord, may I just make one indulgence? They will say all these things because short affidavit directions, short. Kindly hear it. I said it's totally illegal. Kindly hear.
Mr. Banerjee, there are so many learned colleagues of mine. Just go before them and try your luck.
I am not, this much I can tell you, not that I must move people lordships. But what I am on, if direction is for short direction for affidavit, nobody will affect it. Because he says everything is over. Everything is over. One came I've seen. In affidavit, they say no. It was started after you moved this application. What is this? So let the short direction.
Yes, how much time do you want?
Short directions, my lord.
But he said, the court should not trust me. May I hand up the letter of acceptance, my lord?
Have you taken personally?
Let such things from a very senior counsel, my lord. I have to, my lord, take care. Letter of acceptance.
Agreement.
Or আমি তো বলছি এখন স্টেজে
না না আপনি বললেন আমার
have I ever said anything?
আমার
No, not in that case. In that
বিশ্বাস
case,
করতে
I
নিষেধ করলেন
my lord will hear the matter because your lord says, Mr. What am I to do? Because everything is over.
Mr. Banerjee, please. Yes.
Direction. Short directions, my lord.
The petitioner has challenged. What has been rejected? Your technical bid?
my lord.
So far my bid is rejected. I am not challenging.
Page
I'm saying
130.
how that is qualified person.
No, you're not challenging your, but you have,
No.
you have asked for a stay of the notice.
I am not. There is a notification because it is not being followed. Kindly see. 2% illegally has been introduced.
The learned counsel of the petitioner submits that the petitioner is not challenging. The petitioner has not challenged. The petitioner's
Rejection.
The rejection of the petitioner's technical bid, but the selection of the private respondent
5.
number 5
151. Yes,
as
5
the successful bidder in the tender floated by
Page 41, my lord.
Section 7 wrongly introduced. Only to avoid these particular provisions. List 3, it should be cancelled.
Page 41, my lord.
tender issued by the superintending engineer and project director, PW Roads Directorate on 10/3/2023. Stop. Next, the respondents, who is for the private respondent? You. The respondents are called upon to file their respective reports in the form of affidavits.
Very short, my lord, very short.
By 9 June 2023. Reply by.
I'm grateful. Within a week? Within a week?
By 12th June 2023.
My lord.
Reply within
1 week.
Reply by 19th June 2023. List this matter on 20th June 2023.
We are grateful, diplomat. Avoid with that, my lord. Since matter is sub judice.
No.
No.
I have not even heard it. Why should it abide by the result?
Lord, may I take back the documents?
Heard them.
Total illegal. Only to oblige 2 persons. They are following the government own circular. Less than 2, 3 cannot be. Anyway, I'll satisfy you. Oh, affidavit of service is filed, kindly recorded, my lord.
The affidavit of service is taken on record.
I'm deeply loaded. May I leave, my lord?
Item number 14.
My application, my lord. Why not vacation bench? I'll indicate you also. There is a threat that they will invoke my bank guarantee and forfeit the security deposit. The termination is of 25th February 2023.
Where is the affidavit of service, Mr. Banerjee?
No, I haven't checked. I'm told we've served. I'll just check and hand it over. Yes, it's been served. On 2nd of May. 2nd of May, we've served.
Who is the answering?
The
respondent?
Northeastern Railway. But I'll address your lordships on all the points that they can take. First point that will come up is 226(2). The other point is going to be the arbitration clause. And both points are covered. I'll just indicate, my lord, a contract is entered into between me and the Northeastern Railway. I get disregards the papers for now. My lord, I understand it's the last day. I'll not take your 5 minutes of your lordship's time. 3 dates are important. One is 8th of February 2023, when apparent 7-day notice is given to me. Then the next date is 18th of February 2023, when they say that less than 10% of the amount is in default. Then there is a 7-day notice, which is on 22nd February 2023. And the termination happens on 25th February 2023. Why is it urgent? The bank guarantee and the security deposit has not been forfeited yet. If they don't do it for the next 14 days, the lordship keeps it on the 8th. We'll come back and trouble your lordship on just that.
No, where is the threat of forfeiture?
Yes, that is your lordship will find at 260. Yes, 273. Kindly have a look at 273.
This is what is under challenge.
Yes, this is the part of the notice of termination. 272 is under challenge. 273 is also under challenge. The last paragraph. At 273. Since the period of 48 hours has already expired.
So 272 is the notice of termination.
Yes.
Yes.
And I'll show the clause. 273 is a consequence of termination. The termination itself under challenge. This forfeiture is also under challenge. Paragraph 2, since the period of 48 hours notice has already expired.
48 hours notice for what?
For your lordship is aware, under clause 62 of the general terms and general conditions of contract, I'm required to be given a 7-day notice. That is supposed to be followed up by a 48-hour notice. 7-day notice is a
before termination.
Before termination. Now, 7-day notice is a remedying notice. It's a notice to remedy the breach. That they give me a notice and they say that you supply 150 glued joints to a particular section. The next letter after that says only 15 of those glued joints remain outstanding.
What remains?
Glued joints is what I'm supplying under the contract. This is in respect of maintenance of a section of the railway from station X to station Y. So within that section, whatever stations are there, I am supposed to maintain and supply these glued joints. By the 7-day notice, they tell me that 150 of such glued joints I have to supply.
You're not saying rude, are you?
No, I'm saying glued.
Glued.
Not not LEWD.
Yes.
No. And then the next notice is that only 15 are remaining. Then the 48-hour notice is in respect of all the sections. So my first point is that the 7-day notice is in respect of one. The 48-hour notice in respect of others, which is not a part of the 7-day notice. So it is not in conformity with the requirements of the general conditions of contract. In any event, the clause specifies that if the breach is less than 10%, then it can't be terminated. In other words, it can be terminated if it's in excess of defect in supply of a quantity more than 10%. Admitted position by the letter, I can show that this was less than 10% because 150 and 15.
So you're saying that there is no defect? But even if there is defect, it is less than 10%.
Yes.
Defect in supplies.
Yes, that is my.
Are you not saying that there is no defect?
No, I'm not saying there is no defect. I can't place my case that high, but I'll just restrict my case to the 7-day notice and the 48-hour notice. There are breaches galore.
Yes, yes.
There is a defect, but the only thing that is to my advantage is the contract was extended in December, which was when it was supposed to expire.
Yes.
Till 31st March 2023, invoking clause 17A2,
which is where the delay is not attributable to either of the parties. So in December, when you extend it without imposing any liquidated damages on the count that is not attributable to either of us, then in February, you supply 150.
So it's the defect, the breach is not of non-performance, it's defective performance,
Breach is of non-performance,
non-performance,
non-supply.
non-supply.
From what it appears to me from their documents is that supply is restricted to less than 10% of what the supply has been called upon by me by the 7-day notice. And 7-day notice in respect of a particular section, the 48-hour notice is beyond that. So the 48-hour cannot be in conjunction with a 7-day notice, and therefore the termination itself is banned if it's not preceded by a 7-day notice and a 48-hour notice. This is the long and short of it.
So the document which you showed me, that gave you 48 hours notice.
So that is subsequent to notice of termination. Your Lordship put a query to me that where is the threat? The threat is 273, that they will forfeit my security deposit and encash the bank guarantee on the basis of a termination which is page 272. The notice of termination is on the basis of my non-adherence to the 7-day notice and the 48-hour notice. I am challenging the 7-day notice and the 48-hour notice itself.
Yes.
And therefore saying that 272, which is termination, cannot be a logical sequitur to these two notices. Issue of 226(2) will arise because all respondents, everything has happened outside. Had the respondents been here, I would not have indicated this. But if they're not there, ex parte, it's my duty to address this, indicate this. That 226(2) would be an issue. I'm covered. I've said that I was within. The participation happened from within. The notice of termination was received within, and the bank from which the bank guarantee has been given is from within. The part performance of the contract is from within. There's a specific paragraph with regard to that, and I'm covered. That is at paragraph 67.
So why do you think they will take that point?
They will take that point. Not any good lawyer, any lawyer would take that point because it's available to them. But I'm covered by that, by your Lordship decision of Jayaprakash. Radhesham Pandey. There is also an arbitration clause in this that is also covered, very, very succinctly dealt with. Just have a look at paragraph 6, paragraph 5 of this judgment. We had found this judgment before, so the drafting is exactly on the basis of this. So I'll just indicate that paragraph.
Paragraph 6?
Paragraph 5.
Right.
Paragraph 5 of my Lord's judgment. Since a point of maintainability has been raised by the respondent railways, this point is being dealt with first. The impugned letter of termination dated 31st March 2021 was received by the petitioner in Howrah within the jurisdiction of this court. The entire cause of action of the petitioner arises from this letter of termination. The impugned letter not only terminated the lease agreement, but also debarred the petitioner from taking part in tenders for the next 2 years. The impugned letter was served on the petitioner's registered office, and the punitive effect of said letter was received by the continued within the jurisdiction of this court. Besides this fact, the petitioner participated in the tender from his office situated within the jurisdiction of this honorable court. The security deposit submitted by the petitioner was drawn on a bank, namely so-and-so, within the jurisdiction of this court, and the respondent authorities always sought to liquidate the security deposit from the bank within the jurisdiction.
This is more of the facts of that case, Mr. Bhattacharya.
Identical here. Kindly compare it with paragraph 67. All these line by line are identical to this. Your Lordship can take my word for it. 67, these pleadings are there. Everything has happened from within. So 226.
Just now you said that you saw the judgment and you drafted that paragraph.
Because factually it was relevant.
Yes.
We found it and then factually it was relevant. That I'll be able to show.
Very well.
The next issue that can arise is of arbitration clause in the general conditions of contract. The latter part of that is again the arbitration clause. Your Lordship judgment covers and considers all the Supreme Court decisions and holds that.
Which one?
Paragraph 5.
Paragraph 5.
Paragraph 5.
Yes.
Your Lordship has seen. Then 6 is with regard to alternative remedy in respect of an arbitration clause. Then CG Power is considered, Whirlpool is considered, Harbans-Lal is considered, Unitech is considered. So instead of citing all these separately, I can just rely on this.
Yes.
And it says arbitration clause when it's arbitrary is not a bar. The arbitrariness I shall be able to demonstrate in 30 seconds from 2 documents. Just bears with me. Page 260.
No, that 7 and 48.
7 and 48. I can just show it because Just one paragraph. Kindly have a look
That
at,
is, both are under clause 62.
both are under 62. And 62, I can also show that if it's not in excess of 10%, it can't be liquidated. It can't be terminated. So that is the essence of my challenge here. So at least till reopening, they should not go.
62.
62, your lordship will find at page 153. (62)(1) Roman 8. Failure to adhere to the agreed program of work by a margin of 10% of the stipulated period. Your lordship will just once have a look at page 265 once.
Roman, which one?
8.
8.
62(1) Roman 8.
Agreed program of work by a margin of 10%.
% of the stipulated period. Now, therefore, if there is a failure, he has to give me at 154 penultimate paragraph,
Yes.
he has to give me a 7-day notice. So 62(1) starts as if the contractor should, disregard the rest of it. Then and in any of the said clause. It starts like that. If the contractor should, then your lordship will look at 154 penultimate paragraph, then.
Yes.
And in any of the said clause, the engineer on behalf of the railway may serve the contractor with a notice in writing to that effect. Now, to that effect, and if the contractor does not, this is important, not within 7 days after the delivery to him of such notice, proceed to make good his default, insofar as the same is capable of being made good. So the default, now kindly have a look at 265. Last paragraph of 265. Disregards the first of how there's a failure, targeted sections, all of that. I'll just come to the crux of it.
Yes.
Because it says you are therefore. So it obviously is a conclusion of the alleged breach.
Yes.
You are therefore instructed to supply fabrication material for 150 number of 60 kg in situ glued joints and arrange to deploy the teams in Daliganj Malhar section. So 150 now kindly turns over, my lord, to 267.
Yes.
The paragraph in between. It has already been intimated PNI of the Gomti Nagar is in progress. P, I could not ascertain what it is. NI is non-integrated.
Yes.
Non-interlocked, sorry. Of the Gomti Nagar is in progress. And CRS inspection is scheduled on 3rd March.
Yes.
As on today, there is about 15 number of glued joint backlog that may be increased in further. So that's less than 10%. Also very important, I should have pointed out that this inspection is scheduled on 3rd of March 2023. Your lordship will find that termination has come on a day before that, which is on 25th February 2023. So supply 150, inspection on 3rd March.
Yes.
Defect is of 15. The rest is a hypothesis.
Yes.
And termination on 25th. Now, this is
And
my
what is 8th February and 18th February?
18th February, your lordship is looking at?
No, you mentioned these dates.
Yes.
8th February.
8th February is a 7-day notice that I just placed.
Yes.
18th is what your lordship is looking at page 267.
Yes.
The next date I had mentioned was 22nd February.
Yes.
That is the 7-day notice, the apparent 7-day notice, and 25th is the termination.
Yes.
So I'm saying that there is no 7-day, there is no 48-hour notice.
Yes.
In consonance with the requirement of the general conditions of contract. The defect is admittedly less than or does not exceed 10%, because 150 and 15. Your inspection is scheduled on 3rd of March. You've terminated the contract before. Now, one thing I'll need to show to your lordship, one page, my lord.
So first 7 days and then 48.
Then
hours.
48.
So 7 days was given to you, but not 48 hours.
48 hours is on a different premise.
Yes.
7 days only with regard to those 150.
Yes.
And in respect of a particular section,
Yes.
48 hours is beyond covering all three.
Yes.
So defect in respect of all three, I've not even been called upon to cure. The only thing that you called upon me to cure, I've cured that for a sum in less than, sorry, for a breach that does not exceed 10%.
Yes.
One thing I'll need to show, my lord, if you have to show to your lordship why it should not be encashed or not forfeited, just once, page 154, 155. 62.2.
Yes.
Just the heading. Right of railway, kindly mark the next word, after rescission of contract. So if the rescission is not in accordance with the contract, this right
Yes.
cannot be, my lord, had this not been the day before the vacation, I could have argued the whole field, but not required because the right that comes after the rescission, if the rescission is not in accordance with the contract, this right cannot be exercised. My lord, these are my
And the right is to forfeit.
right is to, they say that they have a right to, yes, that right is there. That right is there. Whether they do it in accordance with 62 is a different challenge, but they have the right under 62 to forfeit and to encash the bank guarantee. Of course, forfeiture of secure deposit now is covered by Kailashnath, that you can't do it without actually proving a loss. But then I don't think at this stage, I need to trouble your lordship with that much. I am at a step on a challenge that precedes that right.
Yes, the affidavit of service is kept on record. Stop. The answering respondent, which is the Northeastern Railway, is not represented.
Look, could I just take back the affidavit of service once and check it against once more?
Shows 2nd May. Check it.
No, I've checked once. Yes, yes.
Stop. The petitioner has challenged three notices issued by the respondent railways, the last of which is a notice of termination dated 25/2/2023. Stop. The contract was for the petitioner providing a certain quantum of glued, GLUED, glued insulated joints, capitals, to the railways. Stop. The notice, the impugn notice alleges, the impugn notice of termination alleges that the period of 48 hours given to the petitioner has already expired and the contract hence stands rescinded in terms of clause 62 of the general conditions of contract, within brackets GCC. Where does it start?
Starts at the GCC starts at page 65. ठीक तो रे? Yes, yes. 68, your lordship will make a note.
Capital 7. Standard Indian Railways Standard General Conditions of Contract, 2019, September 2019. Stop. Next, on a prima facie consideration of the material placed before, of the documents placed before the court, it appears that the impugned notices at least of termination dated 25, at least of the termination dated 25/2/2023 suffers from prima facie, from a non-compliance of clause 62 within brackets 1 of the GCC in terms of the conclusion arrived at by the respondent that the petitioner, that the termination was justiciable in view of the failure of the petitioner. Stop. 62.1 within brackets 8, Roman 8, Choto, deals with the obligation of a contractor and the circumstances where the obligations would be deemed to have been failed, would be deemed to have not be to have been breached, would be deemed to have been breached in respect of the failure to adhere to the agreed program of work by a margin of 10% of the stipulated period. Stop. This failure would result, in the engineer on behalf of the railway serving the contractor with a notice in writing to cure the defect within 7 days from the delivery of the notice. Stop. The next, the একই paragraph করো. The material, the material shows that even if it is assumed that the petitioner was as the contractor, was in breach of the obligations under section 62 within brackets 1, it is arguable whether the breach exceeded the margin of 10% of the stipulated period under clause 62.1 within brackets Roman Choto 8, close brackets. Stop. Next, even otherwise, the contract was, the tenure of the contract was extended in December 2022 till 31/3/2023, whereas impugned termination is dated 25/2/2023. Stop. Further, the date of inspection of what?
Of the CRS inspection. I'll tell you, Lordship,
What is CRS?
CRS full form ki bolli? Commission Railway Safety.
Of the commission Railway Safety within brackets CRS, close brackets, was fixed on 3/3/2023. But the termination, however, was of 25/2/2023. Stop. Next, learned counsel appearing for the petitioner has raised other grounds which would call for interference of the court, including the period of notice to be served on a contractor, on the contractor, including of the 48 hours. Stop. Is that correct or not? Stop. Next. Hence, comma. Before the respondent railways is given a chance to respond to the charges made, to the allegations made, comma. The respondent railways shall be restrained from acting in terms of the impugned notices, including the notice of termination of 25/2/2023, or forfeiting the security deposit.
Yes,
The security deposit of
the security deposit and from enforcing the, encashing the bank guarantee.
security deposit or encashing the bank guarantee. Performance bank guarantee.
Yes, performance bank.
Encashing the performance bank guarantee of the petitioner. Stop. List this matter. Next, list this matter on in the reopening week on 8th June. List this matter on 8th June 2023. 9th June 2023, which is the reopening week. Stop. The order shall be communicated to the railways in the course of today. Stop. Today, Mr. Banerjee?
Yes, Manoj, I'm told that the server is down, so we will have to take it from the department. Lordship will give me a liberty to communicate this order.
Since there is a continuing problem with the server of the court, the petitioner is given leave to communicate the order on the respondent railway by 12 p.m. tomorrow,
Great, Manoj.
i.e. 20th May 2023. Stop. Next, the railways shall be at liberty of seeking appropriate relief against the order passed before the vacation bench, if it so deems fit, but upon notice to the petitioner. Stop.
I'm very grateful, Manoj. Probably
The actor line lekho to. Any issue which the respondent may wish to raise with regard to the maintainability of the matter, maintainability of the writ petition, shall be gone into on the returnable date. Stop. Maintainability of the writ petition or alternative remedy shall be gone into on the returnable date. Stop.
Grateful, Manoj. And I hope your Lordship has an enjoyable summer break. Manoj.
Thank you, Mr. Banerjee, to you and all those present in court.
Thank you, Manoj.
Doctor.
Your item number 14.
For the respondent number 7.
Your Lordship, I am appearing for the petitioner on behalf of my learned senior.
I am
Yes.
for the.
Jalpaiguri
Will you
matter,
just
item
stop
number
making
1.
your submissions? No matter has been called. What is this? You just hear what is being called on. Are you appearing in the Jalpaiguri matter? Yes.
Your Lordship, I've given notice, Your Lordship. Notice has been given, Your Lordship. It was sent by WhatsApp because
I can't understand you.
the notice was sent by WhatsApp, Your Lordship, because the advocate for the other side had said so. It's there, the notice I have given.
Yes, you're there, Mr. Borman.
Lordship, we have already, Lordship, in item number 1, we have already filed the report in seal cover as per last order dated 12th May 2023. Report of superintendent
Who are you appearing for?
for state.
For the state?
Lordship,
Field cover over here. Why is it in sealed cover?
It was so directed, report of the Superintendent North Bengal Medical College regarding the condition of the mother and the fetus.
Your Lordship, the
Condition
matter
of the
is
mother.
This case, they are praying for termination of pregnancy. Yes, Lord.
16-year-old rape victim. 16, Your Lordship, a 16-year-old rape victim girl. Her mother sought for medical termination of her pregnancy. By this writ petition, were made representation.
What is the
She's-
duration?
8 months.
8 months.
8 months.
That is way beyond the act.
But because that is why the special permission was sought. In the act, Your Lordship, there is a provision where if
How can I say
there
yes?
is a risk, there is a risk involved. She suffers from, Your Lord, the child, if given birth to, will have a neurological disorder, and she's
What
a rape
about
victim.
forget about the child? What about the health of the mother?
That also, that is why, Your Lordship, the direction was given whether the board to decide whether it is possible or not.
Not possible at 8 months to say yes.
The board has given its opinion, Your Lordship. It is possible if a rape
No,
victim is
no.
allowed to.
Show me the act.
Your Lordship, the act, section 3, Your Lordship. And he looks, Your Lordship.
এটা কি না না করছো কেন আগে দেখো What does the act say?
The act says that if it is after 12 weeks, it is not possible. But if there is any medical reason for which it is required, it can be. There is a medical.
12 weeks and 8 months.
Yes, Your Lordship.
Do you realize the difference?
Yes, Your
The
Lordship.
mother
but
may
there is-
die.
That is if she's allowed to give.
So
birth
you want
also,
to
if she's allowed to,
please, who is the petitioner before the court?
the mother of the victim.
Then the mother does not care whether her daughter dies in the
That,
process.
that is why, Your Lordship, the board has given its opinion that it will be more risky.
Board says that it may even lead to maternal death. That is the report of the board.
Then Your Lordship kindly
Then-
decides according to the report of the board.
How old is the girl?
She's 16, 17 years old, Your Lordship. She's a rape victim. That is the thing. Your Lordship.
Please mute yourself. Which section is this?
Section 3, Your Lordship. Your Lordship, subsection 2, clause I, 1 and 2, Your Lordship. B, 1 and 2.
Please. 5 months outside window, and here it is 8 months.
Yes, Your Lordship.
When did you file the writ petition?
Writ petition was filed in May 4 this month, Your Lordship.
This month. So why did you wait for 8 months?
Your Lordship, I have no instructions regarding that. I was instructed by the advocate who is appearing before the learned Jalpaiguri circuit.
There is absolutely no reason for you to wait for your daughter to become 8 months pregnant and then file a writ petition. And now you want an order before the vacation.
Your Lordship, because after 9 months, the report.
And why are you not before the Jalpaiguri bench?
Because
Why did you not go before the Jalpaiguri bench?
It was moved before the Jalpaiguri bench. The order was given on May 12, Your Lordship. Thereafter, because after 9 months, so she will anyways will have to give birth. That is why it was urgent. That was I mentioned.
Naturally.
Yes, that is the.
Then why did you wait for 8 months?
I understand your lordship, but they had this, she's a rape victim.
And who will take responsibility if the petitioner's daughter dies? Who will take responsibility? And the court will say, yes, go ahead and medically terminate her pregnancy.
Your lordship kindly decides according to the opinion of the board, whatever your lordship takes this decision.
Yes, what does the board have to say? Mr. Borman?
Lordship, the report is, there is a danger of the mother also, the report says. And already 34 weeks, 3 days on the date of the board's report.
She was how many weeks pregnant on the date of filing of the writ petition?
31 weeks, 5 days.
31 weeks.
5 days.
Which paragraph in the writ petition says that the mother does not, the petitioner does not want her daughter to have the child?
Paragraph 4, your lord. She is now 30 weeks plus pregnant. Paragraph 4 and your lordship.
She was 30 weeks pregnant on the day of filing of the writ petition. What did she say? She was, this happened, the incident happened on the date of the funeral. Whose funeral?
Father's funeral.
Whose father?
Her father's funeral.
The petitioner's?
Husband's.
The petitioner's husband's funeral.
Husband's.
The daughter was?
Yes, your lordship.
And who is this Bobby Tamang?
He's the accused person.
I know he's the accused person.
But his relationship, your lordship, with the, I have no idea regarding that.
Who will take the, who will give the guarantee, Mr. Or the undertaking, Mr. Borman? If anything happens to the petitioner's daughter?
Since the daughter is minor still now, less than 17 years, mother has to take the, because she is the petitioner.
And the Jalpaiguri Circuit Bench did not just said that you file a report.
Yes, your lordship, May 12 order, your lordship kindly looks.
They have moved on the last date.
You wanted matching of the DNA?
Your lordship, with regards to whether the body tamang is the, that was directed, I did not seek that such prayer. It was directed by the court, your lordship. If it can be preserved for the criminal investigation.
You have to give a consent in writing.
Yes, Your Lordship.
Have you given that? Is it before the court or not?
Your Lordship, consent, this is not before the court. As per the last annexure, Your Lordship, there by the advocate, a representation was made and subsequent representation.
You, the mother, will have to give a
Yes.
consent in writing. What advocate?
That had Your Lordship, at each Your Lordship had sought permission for page 16. At page 16, Your
The
Lordship.
petitioner claims to be the widowed mother of a minor victim girl aged 16 years who was raped by the accused person on the day of the petitioner's on the day of the funeral of the petitioner's husband. That is the father of the minor victim girl. Stop. The petitioner 16 or 17 crore. The petitioner seeks medical termination of pregnancy of her daughter. Stop. The petitioner's daughter is presently is 8 months pregnant at present. Stop. The petitioner's daughter was 31 plus weeks pregnant, 30 weeks plus pregnant at the time of filing of the writ petition on 3rd May 2023. Stop. Next paragraph. The matter was moved before the circuit bench at Jalpaiguri, and by an order dated 12/5/2023, a coordinate bench directed the superintendent, North Bengal Medical College and Hospital, Shiliguri,
Yes, Your Lordship.
Shiliguri, to form a medical board for the clinical examination of the petitioner's daughter and the fetus, and to file a report and to submit a report. Stop. The medical board was also directed to give their opinion as to whether the fetus can be preserved for matching of the DNA for evidence in a case under in a case. Now, if the petitioner sought to initiate any case under the POXO Act, which year is it? 2012.
2023, POXO Act, 2012.
2012. Stop. Next, the respondent Department of Health and Family Welfare, and the Chief Medical Officer, CMOH is represented. Stop. Learned Counsel files the report of the medical board in a sealed cover. Stop. The report is dated, the medical report is dated 15/5/2023. Stop. And states that although termination of the advanced stage of pregnancy states that termination of the advanced stage of pregnancy may invite minor to serious complications to the mother, including maternal death. Stop. The petitioner's daughter was found, the psychiatric mental state of the petitioner's daughter is also part of the report. Stop. The court does not wish to reproduce or state the contents of the report as to the victim girl's mental condition in the order. In the order. In this order. The report, however, concludes that the consensus of the medical board is that the pregnancy can be terminated as per the existing MTP Act. Stop. Next. Section 3 of the Medical Termination of Pregnancy Act, 1971 provides for termination of pregnancies by registered medical practitioners. Stop. Section 3 within bracket 4 within brackets 2, section 3 within brackets 2 provides that a pregnancy may be terminated by a registered medical practitioner where the length of the pregnancy does not exceed 12 weeks or where the length exceeds 12 weeks but does not exceed 20 weeks. If not less than 2 registered medical practitioners are of the opinion, formed in good faith, that the continuation of the pregnancy would involve a risk to the life of the pregnant woman or grave injury to her physical or mental health, or there is a substantial risk that the child, if born, would suffer serious physical or mental abnormalities as to be seriously handicapped. Stop. The medical report of the board states by consensus that the pregnancy may be terminated, but that such termination may invite minor to serious complications to the mother, including maternal death. Stop. Section 2 within brackets छोटो b within brackets छोटो I is the first provides that provides that a pregnancy which exceeds 12 weeks, which does not exceed 20 weeks, may be terminated by not less than 2 registered medical practitioners, provided the continuation of the pregnancy, provided the 2 medical practitioners, provided the 2 or more medical practitioners opine in good faith that the pregnancy would involve a risk to the life of the pregnant woman or of grave injury to her physical or mental health. Stop. Explanation I provides that where the pregnancy is alleged by the pregnant woman to have been caused by rape, the anguish caused by such pregnancy shall be presumed to constitute a grave injury to the mental health of the pregnant woman. Stop. Section 3 within brackets 3 of the Act further provides that in determining whether the continuance of a pregnancy would involve risk of injury to the health under subsection 2, account may be taken of the pregnant woman's actual or reasonable foreseeable environment. Actual or reasonably foreseeable environment. Stop. All that follows next, all the subsections which follow, all the subsections and explanations which follow section 3 within brackets 2 within brackets choto b are on the premise of the pregnancy not exceeding 20 weeks. Stop. In the present case, comma, the petitioner's daughter was already 30 plus weeks pregnant at the time of filing of the writ petition. Stop. It is inconceivable that the petitioner, comma, knowing fully well that her daughter was a victim of rape, and that too "30 weeks before filing of the writ petition, comma, would wait for her daughter to reach an advanced stage of pregnancy before approaching the court." Stop. This has not only resulted in increasing the risk of her daughter's physical and mental health in the interregnum, but also in the event of termination of her daughter's pregnancy. Stop. The main contention of the primary contention of the petitioner is that the pregnancy should be terminated since the pregnancy was unwanted and is a result of a rape committed on her daughter. Stop. Explanation I to section 3 within brackets 2 within brackets choto b supplements the grave injury to the mental health of the pregnant woman being one of the circumstances where a pregnancy within 20 weeks may be terminated. Stop. The supplemental reason is where the pregnant woman, where the pregnancy has been caused by rape. Stop. Although this appears to be the main consideration of the present case, as also the victim girl being a minor at the time of the offense, on the date of the offense. Stop. Next. Although the mandate of the act is clear that a pregnancy cannot be terminated which after 20 weeks, comma, this court is of the view that termination of pregnancy, comma, for most for women who are who have attained the age of majority, and for those who are minors, comma, should be a matter of choice. Stop. The importance of having and exercising that choice is all the more relevant where the pregnancy was unwanted or a result of a forced non-consensual act. Stop. A woman cannot be burdened with a child. A woman cannot be deprived of the right to choose whether the woman wants to have a child or not. Stop. The right of choice, the right to choose, would also include the awareness of the health risks which would accompany the termination of pregnancy. Stop. It would, if a woman chooses to terminate her pregnancy, comma, it should be assumed that the woman has also exercised that choice, the choice to suffer the consequences of termination of pregnancy to her physical and mental well-being. Stop. The MTP Act is of 1971. And the law with regard to the rights of a woman to her self-determination has also developed in the meantime. Stop. Next, in the facts of the present case, comma, the petitioner's daughter is a victim of rape. Stop. The medical report reflects the mental condition of the petitioner's daughter brought about by the act of rape. Stop. Without going into the details, comma, the report states that the petitioner's daughter is suffering from mental distress caused by the act of rape and sexual abuse. Stop. The report of the medical board, this and the consensus of the medical board strengthens the hand of the court to permit the termination of pregnancy of the petitioner's daughter. Stop. Needless to say, the court has been made aware, by the report, by the contents of the report, that the termination at such an advanced state of pregnancy may result in severe consequences to the petitioner's daughter. Stop. The larger ramifications and consequences if the termination is not permitted would, may, endanger the mental agony of the petitioner's daughter, so as to constitute a grave injury to the mental health of the pregnant woman under explanation I of section 3 within brackets 2 within brackets choto b of the Act. Stop. Next, the petitioner, as the mother of the minor girl who is to undergo the procedure for termination of pregnancy, shall give a letter of consent shall give an undertaking to the shall give her consent in writing as the guardian of the minor child, of the minor girl, to the termination of pregnancy. Stop. The letter of consent should be given. This is a requirement under the Act. Stop. The letter of consent should also state that the concerned hospital or the medical practitioners who undertake the termination of pregnancy shall not be held responsible for any risk to her daughters, to the girl, to the victim, to the minor girl's health or life. Stop. The consent of the of the minor girl shall also be taken by the concerned hospital before the termination of pregnancy, before the pregnancy is terminated. Stop. Next, WPA 1140/2023 is accordingly is disposed of in terms of the above. Stop. It is needless to say, the petitioner shall take expeditious steps to act in accordance with this order to prevent any further risk to her daughter's physical or mental health and well-being. Stop.
Your Lordship, urgent certified copy because the server is not working, Your Lordship, for server copy.
Urgent certified copy.
Grateful.
Chamber.
Your Lordship, if
You collect the book later on, please.
Your Lordship, plain copy, if urgent, plain copy when the server is not working.
Plain copy kore do. Yes, call on the next matter, please.
Daily list item number 15.
I am for the private respondent number 8. 8. Private respondent number 7.
Yes, what is the urgency?
Your Lordship, I am appearing for the petitioner.
Police in action.
No, this is not a police in action, Your Lordship.
Kindly see the prayer.
What is the urgent relief you want?
Kindly see the prayer. See. Read
Your
in
Lordship,
the nature of mandam also directing upon the respondent number 3 SP 4 SDPO 6 OC Narendrapur Police Station.
Yes,
Your Lordship, I am the petitioner. Please allow my
No. This court does not have determination to entertain
Your
the matter.
Lordship, I am not only prayer against the police, Your Lordship. Please come to prayer
stop.
B, Your Lordship.
The petitioner is given leave to move the vacation bench. Next.
Item number 16.
That I appear for the petitioner. That I started working on a contract. With undue haste, the Zilla Parishad, the Purva Medinipur Zilla Parishad terminated the contract by deviating from the clauses of the tender, caused a measurement to be made insofar as the work so far executed is concerned, and after serving a copy of the writ petition, they have caused a retender to be issued.
Mr. Mojumdar, you go for the vacation bench, please. Not leave. Granted.
Only if this could be for a period of at least till 5th or 6th, kindly have a look.
No, Mr. Mojumdar, I will not hear it. What relief do you want?
They are trying to enter into the property insofar as my execution of the work is concerned. Number
Who is
one,
they?
the Zilla Parishad.
Yes.
Lord, kindly see
In
your
gross
Lordship,
deviation from the tender
kindly see
clauses.
the Lord. The Jilla Parishad has cautioned several days. Is so-called notice. They did not turn up. Lord, what happened? Lord, this is the urgent work. Lord, to turn. Lord, change them. Lord.
What is the relief you want, Mr. Mojumdar? Vacation bench.
Status quo as regards the position of
No.
Drinking water.
Please have a look at the impugned order at page 73.
No. Mr. Mojumdar, vacation bench. No. Yes, leave to move the vacation bench. Yes, since the petitioner, since learned counsel for the petitioner prays for urgent relief, leave to move the vacation bench. Next.
Item number 17.
Similar.
Same. Next.
And
Item number 18.
Same.
With notice.
It's not a so safe environment. What is it?
I beg your lordship.
It is not a so safe environment. Yes, next.
Item number 19.
Not given the choice, we always try to exercise.
Yes. Mr. Mitra, if you're asking for a interim order, I'm giving you leave to move the vacation bench. All right.
The whole difficulty is, my lord, your lordship, it appears, sorry.
Yes.
It appears your lordship has gone through the papers, my lord. The whole difficulty.
What makes you think that?
I'm sorry. Ma'am.
What makes you say that?
No. Your lordship knows the facts, my lord, possibly.
This fact? Why? How should I
I
know?
see. Ki korbe?
It's the first time I'm hearing, seeing the
I'm sorry,
papers.
I'm sorry, my lord. I thought that your lordship read it, my lord. The whole difficulty, I will tell your lordship, my lord, I was interested with the work.
Mr. Mitra, you're asking for a relief. What is that relief?
The relief is, my lord, that they should not, my lord, allot the work to somebody else because I was doing the work.
So it's a tender matter?
Yes.
Yes. No tough decisions on the last day of the vacation. So you go for the vacation bench.
The only difficulty is, my lord, if they wait for, my lord, I have a good case, my lord.
Monday is the vacation bench. Not happy with the lineup?
My learned friend is there, my lord, at least.
Your learned friend looks that he doesn't have a clue as to what you will ask for. That's why he's looking very confused. Yes.
I was only asking, my lord, let them not do anything till Monday, my lord.
What will they do? I'm asking you.
They will open the financial bid, my lord. If the financial bid is open, my lord,
Yes.
They have participated in the financial bid.
without prejudice to my rights, I had to because they did not respond to my.
Mr. Mitra, it is better that you go for the vacation bench rather than do this matter before me. Because tender matters, these kinds of matters, I take a view. I don't want you to suffer that view. So go for the vacation
I thought
bench.
I could change that, my lord.
Not on the last day. Maybe some other time. Best of luck, but not today.
We participated without prejudice.
I don't know why all of you, if you want to wait till June, you're most welcome to, but I think that why will you not work for your client at least?
May my lord mention may it be happen like we will not issue, my lord, we will not issue the letter of acceptance. The tender process may be continued. And after
You're conceding. Did I
Yes.
ask you to concede?
No, my lord, I agree to this, my lord. I agree to this, my lord. Kindly take it up on the.
Don't tell me that it's the court. I did not even say anything against you.
No, my lord, sorry, my lord.
What sorry?
I agree to this, my lord. Let them not do anything till, my lord, the
Mr. Mitra, I would like to believe that he's not intimidated by the court, but by you. So don't take advantage of that.
I know about my face, my lord. That's the difficulty.
Won't take any steps.
My lord, the tender is already processed, my lord. Only the bidding part is there.
Very
They are
well.
participating.
Learned counsel appearing for the tendering authority, i.e. Southeastern Railway, submits that there should not be any restraint on the authority proceeding with the tender, but that the authority will not issue a letter of acceptance. Why letter of acceptance? You've already given the offer.
Yes, my lord.
No,
No, my lord. Bid is not opened. But if it is processed, my lord, in between
Will not issue any document in respect of the successful until the matter is heard out. Stop. List this matter on you choose a date.
In between June, my lord.
For your sake, I'm fixing it in the second week. All right. List this matter on 9 June 2023.
Deeply obliged, my lord.
Next.
Item number 20. Item number 20.
I can't understand. Yes, affidavit of service is kept on record. Yes.
My lord, item number 20, my lord, I am appearing for the Union of India, my lord. Union of India, my lord, I am appearing for that. I am led by Mr. D.N. Ray.
In this writ petition, my lord, the
Vacation bench. Vacation bench.
my lord,
You're not seeking any interim protection, I presume.
I am, my lord. I am to the extent, my lord, a very nominal order that I am seeking. My lord, I had delivered goods to the railways. They have accepted the goods, they have inspected the goods, all process followed, goods accepted, payments made. Even then, my lord, after payments are made, after 90 days, they have a time to raise an objection as to the quality of the goods. They don't do it within 90 days, but I'm even not taking that point because there is one clause in the contract which says that at any point of time, they can raise this objection. Now, my lord, thing is this, my lord.
What is the interim order you want, Mr. Dutt?
The interim order is they have, my lord, initially given a joint inspection report without notice to me where they have said that the goods are defective. And on that basis, they have issued a show cause notice. I am to reply to that show cause notice. Now, my lord, I am challenging this entire process of, my lord, hearing because the basis on which this
What is the interim relief you want?
interim order I want, my lord, if that report which was prepared ex parte, my lord, should be set aside. But the interim order I want till such time, no coercive steps should be taken against me. What they do is, my lord.
What do you have to say?
As per the arbitration tender clause, that inspection was conducted when the.
You are opposing the interim relief?
Yes.
Yes. Since learned counsel appearing for the petitioner seeks urgent interim relief, counsel is giving leave to move the vacation.
Because, my
Why
lord,
after the vacation?
because, my lord, none of my juniors would be in town during the vacation. That's the reason.
That's a good reason to wait. Yes.
On the reopening day, my lord.
List this matter. The petitioner seeks stay of the operation of an inspection report issued by the respondent railways. Stop. The petitioner also seeks that the respondents should not take any coercive steps in the meantime. Stop. Next, list this matter on. Give me a date, please, when you want.
Well, on the reopening.
List this matter on 5th June 2023 as prayed for.
Well, there have been subsequent developments. I've made a supplementary affidavit.
The supplementary affidavit, a supplementary affidavit prepared
Two
by the
supplementary
two supplementary affidavits prepared by the petitioner are filed in court today. Stop. Copies of the same should be made over to the respondents in the course of the day before the returnable date. Next.
We have not received the copy of this.
Item number 21.
Deeply obliged.
Number 5, my lord. The repetition is at all not maintainable.
Lordship, I'm praying for the interim relief, your lordship. There is a bank account, your lordship. I'm praying that the same may not be allowed to be operated solely by the respondent number 5.
I'm appealing for the respondent number 5.
Private respondent. Lordship, what has happened, your lordship? On the urgency, your lordship, I've mentioned this matter. Lordship, this account which is being maintained, it is with regard to a partnership firm, wherein, your lordship, I am one of the
go to the vacation
Kindly
bench.
see for a moment, my lord.
Lordship,
Vacation bench.
Lordship, the urgency on which I had mentioned, your lordship, the difficulty is that, your lordship, this account, your lordship, the amount is lying there and he will be siphoning off the money. Lordship, he may not be allowed. Your lordship, I'll come back after the vacation.
Learned counsel appearing for the
Lordship,
petitioner
kindly
seeks
take up the
urgent
prayer.
issue.
Lordship, kindly take up
Learned
the prayer
counsel,
only.
no. Learned counsel appearing for the petitioner seeks urgent interim relief in respect of an account which is apparently being used by the private respondent. Stop.
Lordship,
Next, learned counsel appearing for the respondent takes a point of maintainability of the writ petition. Stop. Leave to move the vacation bench. Next.
Lordship, kindly keeps it after the vacation, your lordship.
Then how will it help you?
Lordship, the difficulty is that, your lordship, I have mentioned it, your lordship. This is the account, your lordship.
I'm telling you to move the vacation bench. You're saying difficult. Then you're saying you keep it in June.
Lordship,
I
not
don't
the
understand.
vacation bench,
If it is urgent, then you
Lordship,
go to the vacation bench. I'm
Lordship-
giving you that leave.
Lordship, it is an urgent matter, your lordship.
Very well. Then vacation bench. Yes.
Lordship.
Item number 22.
Yes, in the fixed matters, which are the matters which are required to be considered, or vacation bench in the fixed matters?
22, this can wait. 22, this can wait, my lord, any day after the reopening. 12th, if your lordship.
Yes, list this matter on 12 June 2023 as prayed for.
22 to 26 are only very small matter.
No, I will not hear them. I will not hear them. Who is for the petitioners? 23 to 26?
24
Number
to
23.
I am for the petitioner for
23? 23? Very well, 23, list this matter on 13 June 2023 as prayed for. 24 to 26.
Item number 24
I am for
to
the petitioner, Your
26.
Lordship. I'm just aggrieved by my non-disposal of section 14 application, Your Lordship, pending before the Learned District Magistrate Havra since long, Your Lordship. It has been pending since January 2020, Your Lordship.
January 2020. Yes,
Yes,
Mr. Banerjee. I can't hear you. Please hurry up.
Multiple things will have to be submitted here. Milord, the signature of the deponent, Milord, on the writ petition does not match with the signature, Milord, of the same person, Milord, before Milord, the magistrate. Milord, there are, Milord, certain things which have to be brought to the notice of this honorable court. Milord, this will, Milord, take some time. Milord, I can address your lordship. Wait,
I'm just
then, Milord,
praying for
I will
disposal of.
Just dispose it off, Mr.
Handwriting,
Banerjee.
it's
can't be, Milord, Milord, there is
How
every
is this writ petition important? You're supposed to dispose of the affidavit under section
possibly,
14.
Milord, the writ petition has also not been properly affirmed before your lordship. Milord, there has been some kind of impersonation. Milord, there are, Milord, signatures. Milord,
Impersonation. It's
Kindly,
a
Milord, have a look.
HDFC Bank.
Kindly, Milord, have a look at the signatures.
Yes.
Kindly, Milord, have a look at the signature, Milord, on the page 12.
Yes.
Milord, kindly note the name.
Yes.
And then, my lord, will kindly turn to page 55. Milord, the same person is signing, is claiming to have signed. And kindly see, Milord, the difference in the signature. And Milord, then if I show Milord the affidavit, kindly Milord turn to page 56 then. Kindly see, Milord, who is affirming this. The notary is at Barashat. Milord, the affidavit says, Milord, this is done at Kolkata. Again, Milord, the signature differs.
Yes, learned counsel appearing for the state respondents raises objections.
Milord, I am for the private respondent.
For the private respondent raises objections which are not at all material for the purpose of giving a direction on the authority under section 14 of the SARFAESI Act 2002 for disposing of the application made by the bank, made by the petitioner bank under that section. Stop.
Milord, the application is otherwise incomplete.
The private respondent has absolutely no locus to even bring any points before the court or to the district magistrate under section 14 of the Act. Stop. Next, there has admittedly been a delay in disposal of the application pending before the district magistrate. Stop. WPA 13469 of 2021 is disposed of with a direction on the respondent number
2, Your Lordship, District
2
Magistrate. 2.
to dispose of the application pending with the district magistrate within 2 weeks from the date of this order. Stop.
Kindly, Milord, allow me to make a just representation indicating the
The
incompleteness of
prayer of the private respondent in making a representation is considered and refused since no such right has been given to any other party under section 14 of the Act.
My
Next.
affidavit of service be kept on record.
The affidavit of service is kept on record. Next.
But there was some Milord clarification sought for Milord from the HDFC.
Yes, the petitioner will provide the clarification sought for
That will.
by 23rd May 2023.
Lordship will provide.
Next.
Item number
Next.
25.
Similar circumstances, Your Lordship. Here, the district magistrate Birbhum, the application is pending since February 2019. I have served, Your Lordship, twice.
Yes, this writ petition has been filed by a secured creditor for a direction on the district magistrate to dispose of the application filed under section 14 of the SARFAESI Act 2002. Stop. WPA writ petitionটাও দেবে না কি করছো তুমি? There has admittedly been a delay on the part of the district magistrate. Stop. WPA 13472 of 2021 is disposed of with the direction of the district magistrate to dispose of the application within 2 weeks from the date of receipt of the order. Stop. The affidavit of service is kept on record. Have you served the district magistrate?
Lordship, twice. I have served twice, Your Lordship.
Yes, the affidavit of service is kept on record. No one appears for the district magistrate. Next.
Item number 26.
Your Lordship, the similar matter here, the district magistrate Havra, the matter is pending since February 2020.
Milord, same thing, we sought for clarification, Milord. That was on 29th November 2022. We sought for some clarification, not yet given, Lordship.
Yes, this
May-
writ petition is for a direction of the district magistrate to dispose of an application under section 14 of the SARFAESI Act 2002 pending with the district magistrate. Stop. Learned counsel appearing for the respondent says that the petitioner failed to give the clarification sought for in November 2022. Stop. The petitioner shall give the clarification by 24th May 2023. Stop. WPA 13537 of 2021 is disposed of with the direction of the district magistrate to dispose of the pending application under section 14 of the SARFAESI Act within 2 weeks from the date, within 3 weeks from the date on which the district magistrate receives the clarification from the petitioner, within 4 weeks, 4 weeks.
Lordship.
Next.
Item number 27. 27, my lord. I am for the petition, my lord. I am praying for time.
Learned counsel appearing with the petitioner seeks
matter,
adjournment,
my lord.
seeks an adjournment. Stop. List this matter on 14 June 2023.
Great.
Original side, anybody is here?
Original side, item number 1 for judgment, Dinesh Kumar Birla, was the Institute of Cost Accountants of India.
This court is according to the view that the petitioner has not been able to make out a case for arbitrary or unreasonable conduct on the part of the respondent number 1 institute, which would call for interference. The 2006 rules framed for election to the Council of the Cost and Works Accountants further restricts the scope of interference. WPA 1082 of 2023 is accordingly dismissed without any order as to costs.
Item number 2, in the goods of Anirudh Chamriya.
List a call call. Yes. No one appears for the petitioner. Stop. List this matter on 5th June 2023. Next.
Item number 3.
Lord, I'm appearing for the petitioner for extension of interim order. My lord, the interim order is expiring today.
Mr. Bag, at least by now you should know where to stand in my court.
My lord.
If you still don't know, that's
So
bad
sorry,
luck.
my lord.
Yes, when is it due to expire?
It's expiring today, my lord.
The interim order is expiring today, is due to expire today. Stop. The interim order is extended till 30th June 2023. Stop. List this matter on 6th June 2023.
Very deeply obliged, my lord.
Next.
Item number 4, Mrs. Sham Tatniki.
The interim order is, no one appears for the petitioner. Stop. The interim order is due to expire today. Stop. The interim order is extended till 30th June 2023. List this matter on 6th June 2023. Next.
My lord, I am sorry to intervene,
Next.
my lord.
Don't disturb the court.
Item number
Next.
5, Continental Chemical Corporation.
This is that petitioner is appearing in person.
Yes,
But,
yes, yes.
kindly keep it, my lord, after the vacation.
Yes, learned counsel appearing for the respondent is present. Stop. List this matter on 7 June 2023. Stop. Mr. Kaur, on the last day when you were not here, Mr. Pincha was here. He was very worried that this matter, if there's a change of determination and all that.
Yes.
So I'm just treating it as
Absolutely.
if you don't have an
no,
because I told him that since Mr. Kaur is not here, I don't want to pass that order.
We treat it as a part. of
Yes.
it. I have no objection.
Yes, since an apprehension had been expressed on behalf of the parties on the last occasion, comma, let this matter be treated as heard in part. Stop. The matter has substantially been heard on several occasions. Stop. Court applications, any matters which cannot wait till June?
My lord,
Otherwise, I will give leave for vacation bench.
my
Yes.
lord, I am for the item number 4, my lord. I just outside the door, my lord.
Yes,
and
I
the-
passed an order. Find it out, please. Any other matters which cannot wait till June, or whoever wants leave, I will give you that leave. Yes.
Lord, I would request that the Indorama matter lordship has heard it. Only reply is due. Item number 18. Mr. Bachawat and Mr. Mukherjee was arguing.
Yes, come back after the holidays. Yes, next, any other matter?
My lord, I am for item number 6, my lord. There is an order which has not been complied by the respondents. This is an order dated 20th April 2021, my lord.
Item 6, my lord, I appear for the respondent number 4. Lord, there was a direction for exchange of affidavits. Lord, I had served the affidavit note upon the respondent. I am filing my affidavit today. Lord, I appear for the National Housing Bank. Lord, this matter.
Affidavits are complete.
No, I have not received, my lord.
Yes,
Very
yes, I
well.
have served.
The affidavit in opposition is filed in court today. Item number 6. The affidavit in reply should be filed by
4 weeks, my lord.
affidavit in reply within 4 weeks as prayed for on behalf of counsel appearing for the behalf of learned counsel appearing for the petitioner. Stop. List this matter in the second week of July 2023.
My lord, I have filed a GA, my lord.
Respondent number 4, my lord, to the main.
Affidavit in opposition on behalf of respondent number 4 is taken on record. Stop.
Great.
Stop. Yes, any other matter where leave is required?
My lord, I have filed a GA in this case, my lord, that they have to reply to the GA, my lord.
GA, my lord, has not yet been.
Very well.
taken up.
Let it appear in the first week of July, or you mention and I will list the matter
Yeah, I
in
have
June.
the affidavit service, my lord,
Yes,
for the GA.
affidavit of service is kept on record. Any other matter where leave is required? Affidavit item number 4 already gone. You should have been here. Any other matter where parties require leave?
My lord, item number 2 was for extension of interim order. I didn't follow the list, my lord.
You were not here, so I'm sorry. You will have to find out the order. Yes, any other matter where parties
The leave is not required, but lordship had passed an order directing the respondents to provide me with the 2 copies of deeds, original deeds which were supposed to be released. I am under an obligation before the NCLT to provide those deeds to the private respondents who have purchased the property. Lordship,
what did you want? I will not hear the matter
direction
today.
they have not provided me. Your lordship had given them an ultimatum.
Today, my lord, direction was given to the respondent number 2 to make the necessary rectification, my lord. But Mr. Oyan Banerjee was appearing, my lord. My lord had expressed in my lord order that it should be completed within by today, my lord, when the matter is due to appear, my lord. But today they are not appearing, my lord. I am the sufferer of the position. I have put in the entire money, the entire registration fees 2 years back.
Yes, what was supposed to be put in?
Lordship, the deeds were to be registered.
Please don't argue the matter. What was supposed to be put in? Just answer the question.
The rectification was required to be carried out.
The
On number.
rectification, Lordship,
That
will
can be
remember.
done.
So who has not done that?
But the register.
The state was
number
supposed
2.
None of you are, anyway, any other matter which, no. Leave to move the vacation bench. Go. Yes, any other matters which?
Leave is not required, my lord, but last order, this is item 11, the willful defaulter matter where we had item 10, my lord, willful defaulter matter where my lord had said.
Yes, in June, yes. Any other matters?
My lord, item 17, my lord, I'm led by Mr. Kishore Datta, my lord.
Yes, Mr. Dotto, will leave to move the vacation bench?
The only thing what I was requesting was in one matter, I found where the lordship had directed the matter to be treated as heard in part. This is that MSME matter, my lord. It has been heard on many occasions by my lord. My lord, the private respondent is on reply. reply to reply. If this, in that works contract, whether it applies.
Mr. Dotto, unless the other side is here, I don't say were heard in part.
Milord, they
It will be in June. You come back, I will treat it as heard in part.
But they have spoken to Mr. Soumitra Mukherjee. He has.
No,
he has-
there is another respondent, not only with Mr. Mukherjee. Yes, both sides must be here for heard in part. Yes, any other matter where leave is required?
Milord, kind indulgence, Milord, item 10, actually 22nd May, Milord had said that the decision of the bank will be communicated. We
Lordship,
have
I'm
get the
appearing on behalf of the
representation.
respondent. The respondent bank or your lordship had directed me to give the review committee had to come to a decision by 22nd May. My submission before your lordship, it is too early. Your bank requires some more time. There's a new judgment with regarding to fraud circular. They need some time for the bank to sort out everything and place it before the review committee. It is pending before us. Lordship will grant
We've
us a
also
little bit
made
time.
our representation.
And
Milord.
your lordship, in whatever he says, my lord, here, the
No.
cause
you
of
come-
action,
you
the
come
writ
back
can
in-
be disposed of,
come
your
back in
lordship.
June, you file a contempt. We will see. Yes, any other matter? You file a contempt, we will see if they have not done it. Yes,
It is not up to me, your lordship. The
very well.
RBI
That
has-
is how you face the contempt. If any of my orders which are not complied with, contempt.
If I can indicate, this is
No.
unofficial.
No. Any other matter? Yes, Mr. Bhattacharya? No,
Not leave. I want to do it.
I will give you that leave to go to the vacation bench.
My lord, in item number 8, come.
But I would not want to do it in the.
But in item number 8, may it come in the regular courts, my lord. Item number 8, my lord.